Maybe.
Okie dokie. Tell me when everybody's in.
Looks like everybody's here. Mr. Brady, I see Miss Murphy, Anderson, Daniel Katz. Yes,
Okay, I can hear you
everybody's here.
now.
Everybody's here.
All right.
Okay.
Hello.
Okay, before we get started, everybody who's here representing 1719 South 20th Street, give me your first names.
I'm not 17. That's not the address for my property.
I know.
I
You're
said 1719 South 20th Street.
Miss
Yes,
Anderson, can you hear us?
I can, yes, that's me, Ursula Anderson.
Hi, Miss Anderson. Are you the only one going to be testifying today?
Yes, that's correct.
Okay, so, all right, what I have to do is I have to swear you in. Could you please raise your right hand? Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, now the group for 1721 South 20th Street. Can I have your first names if you are going to be testifying?
Yes, my first name is Rob, last name
Hey,
McKinney.
Rob. Go ahead.
And my first name is Valen, last name Murphy.
Valen?
Yes, it's V as in Victor, A-L-L-Y, N as in Nancy. Murphy.
This is
Okay,
the court
good.
reporter. This is the court reporter. I'm sorry, I did not hear Rob's last name clearly.
It's McKinney, M-C-K-I-N-N-E-Y.
Okay, all right, is that everyone for 1721? It's going to be testifying.
We have
I'm
our
Daniel Katz. I'm here as counsel.
Yeah, we don't swear lawyers in
Okay.
because they never lie. Okay, so that's why we don't
Fair
swear you
enough.
guys in.
But Mr. Katz is here representing 1721 South.
I understand that. I'm only kidding them, okay? Is there anyone else going to testify in either one of these, either one of these houses? So we got everybody. Okay, we will get, so what we're gonna do is, Rob, please raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Okay, Valen, please raise your right hand, swear to tell the whole truth, nothing but the truth.
I do.
Okay, let me see, I can't see.
Ursula.
Was that-
Ursula.
That's it. Okay, let me see something. Yeah, hey, Brad, please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth.
I do.
Okay, I'm Wade Miller, board member.
Amy Rivera, board member.
Pat Agus, board member.
Brian McSherry, board counsel.
Deborah Richardson, Boards Administration.
Philip Motto, boards administration.
Thomas Strybakowski, City of Philadelphia, License and Inspections.
Okay, Tom, please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth.
Yes.
Okay, Phil, read it into the record for both cases, 1719 South 20th Street, 1721 South 20th Street.
Yes, sir. First item is MI 2024-001-130 for the property 1719 South 20th Street. Item number 2 is MI 2024-002-221 for the property located at 1721 South 20th Street.
Okay, Tom, are you waiting till the cases are over before you say something, or you want to do it first?
I'll do it now, and that way I can summarize it up for the board and give you a little bit of background on why and how we got to this point and what the department is looking for.
Okay, go ahead.
So what we have is at the rear of the properties of 1719 and 1721 South 20th Street, we have in the rear breezeway, there is a shared party wall between the two properties that is deteriorating and needs structural repair. There was an unsafe case written against both properties for this associated shared wall. There was an original survey that was done by the second survey district that illustrated that put the position of the wall or the responsibility of the wall to 1719 South 20th Street. It was the department's belief that this survey was actually incorrect and that this is a shared party wall. On March 15th of 2024, department representatives by myself and also a surveyor from the second survey district for the city of Philadelphia went out to the location. The survey was redone by the survey district, and that survey has been changed. That survey, the finding of the survey in re-looking at the property line, it was determined that this is in fact a shared wall between 1719 and 1721 South 20th Street. With that finding, and in speaking with both the owners of 1719 and 1721 at that meeting, we knew that this hearing was scheduled for today, April 18th. It was represented at that time that the department was willing to give 90 days to the owners from today's hearing date. So not only did they have 90 days from today, but before that, they had an additional 30 days to obtain a make-safe permit for the repair of this shared wall. I'll share my screen so that you can see what this wall is and where it is. But essentially, we're going on that belief that the two neighbors, 1719, 1721, will act accordingly and together in getting the permit for the repair of this property. Or
I don't
this
see
shared
pictures.
property, but I'll share the screen. Can everybody see my screen?
We see the screen, no pictures yet.
How about now?
Yes.
There we go.
Okay.
So what we have is this 3-story property is the rear of 1721. This is the shared wall in question. This is
Is that the green wall there?
It's this gray wall on the right-hand side of the picture. I'll increase
okay.
the font, increase
Okay.
the zoom so you can see it. It's this
Okay.
wall here. It's basically deteriorating. The stucco is essentially pulling off the wall. There is water that is penetrating into the top of the into the top and coming in behind the stucco, or what gives the appearance that water is penetrating into the stucco, and it's deteriorating the brickwork behind the stucco to the point where it's opening up at the bottom. It does need repair, and like I said, at a March 15th meeting out on the location, it was represented that the department would give 90 days from today's hearing to obtain a make-safe permit for the repair of the wall. You can see there's another photograph of it. This would be the parging. This would be the original grade at the time the property was demolished. This was where a former structure was, and then new construction went up. But that's where the essential grade line was at the previous location. But up at the roof line, or up what was the roof line up at the top, it looks like there's some work that needs to be done to secure or to prevent weather from penetrating behind this wall. But because there is brickwork behind this, we're not sure how badly deteriorated this underneath brickwork is of this wall.
Okay,
There's a fracture that's on that wall as well, so it needs to be addressed. Does this fracture penetrate into the wall, or is this just the stucco work that needs to be detailed? And it is my understanding that there has been engineers obtained with them visiting out to the location, but that can be addressed by the appellants. And then this is from the roof line, or the second story level. But with that, that's essentially what we want. That's essentially what the department is asking, that the neighbors work in conjunction with each other and get the necessary permit and do the repairs accordingly. With that, the department will rest.
Okay. 1719, Ursula, you want to tell us your part of the story?
Wait,
Yes,
Ursula was not sworn in. You need to swear her in.
Who?
Ursula.
I swore in.
Yeah, I
Did I,
respond.
Ursula?
Yes, you did.
Yeah.
Oh, I'm sorry. I missed it then.
Go, Ursula.
Okay, I just want to share my screen.
Sure.
Okay, so I wrote my original appeal, and it stated that I was appealing because it was a shared wall, and I do agree that it is a shared wall. I wanted to refer to the original design documents that were submitted for the initial survey for the building of my neighbor, 1721. In that document, and this is just the front page of it, the zoning, they have a picture that shows the property lines for both parties in that initial construction document, and me blowing up. The hashtag marks are the property line between my house and their house, and it clearly shows that the wall straddles both properties. I'm just mentioning this because I'm not contesting that this is a shared wall. I do believe it's a shared wall. I also had the survey done by the survey department for the city. And at that time, this was back in July of 2021, August 2021. And at that time, they did indicate to me that this was a shared wall. We drew on the wall, you know, they did the stakeouts of where the boundary lines are between our two properties. And as you see, the pink marking is where they had indicated where the line was separated. And so that is about 2 inches worth of area, which is between our two properties where the wall currently stands. And I just wanted to mention that because in all of my interactions with my neighbors, they continue to contest that this is a shared wall. They contest it with some of the professionals I've sent out there to do assessments of the wall. They've said to those folks that they only have 1 inch and they're only responsible for the stucco. And so I just wanted to just reiterate to the entire group that it is my understanding and my belief that this is a shared party wall.
Sure.
As it advances, I think it's going to take a second. So the reason for my appeal is based on the Philadelphia Code and the statute 3307.2. And that is that the license to enter the adjoining property has been refused by my neighbors on 2 occasions. And so that is the basis of the appeal today that I'm filing, is that they refuse access. The first refusal was on, it was after I provided them on notice on 2/24/24 by a certified letter. I have indication that the certified letter was received by them. And then they did a response, and that response to that letter indicated that they would provide access to the property to any professionals that I wanted for the purpose of remediating the wall. I scheduled a professional engineer to come out Wednesday, February 28th. And give me a second as it advances. And so access was granted, like I said, on 02/27. I received a letter from their legal representative. And then the professional engineer that I hired came out on 02/28, and they refused entry for that person. And so I do have an email from, his name is Frank, and he's a professional engineer. He's licensed, he's insured. They were home, yet they would not allow him to access the backyard. And there's no safety reason, because this person is licensed and insured, for him not to be able to access the backyard because it is accessible through the alleyway. The professional engineer did not need to enter their home to do an inspection of the wall. And so that was the first instance of where they refused access after I had provided them notice. The second refusal was more recent. I provided them notice via a certified letter on 04/01/24 that I had contracted or was attempting to contract with the masonry structural restoration company. And I told them that the company would be coming out on 4/11/24. I gave them the name of the company, the phone number, and the company is called Craft Pro Masonry Restoration. They were coming to do initial inspection of the wall to give a bid. And then I had notification that the letter that I sent them was received because I sent them a certified letter. And then this was last Thursday, 04/11/24, where they refused entry for the professional who was coming to inspect the wall. And so because this was last Thursday, I don't have actually, a certified, notarized letter like I have for the professional engineer. That would be coming at a later date where they would, certify that they were refused access. But I do have their phone number. And so if during these proceedings, if a call is needed to verify that, then that would be acceptable. So again, the reason for my appeal today is that the 1721, my neighbors are refusing access to the professionals that I have contracted to come and inspect the wall. As you saw in the photos that Tom provided, those photos are from a professional engineer that they contracted to inspect the wall. And so I need an opportunity on my own to also do an assessment to hire contractors and individuals, and they're denying that. And so that's the basis of my appeal.
Okay. 1721, tell me your side of the story.
Before that, sir, Mr. Miller, before that, so I just want to ask one question to Ms. Anderson. So you're not disputing the violation, you're just disputing access to the property. So
That's
you're in agreement that the wall needs to be repaired, correct?
Yes, exactly. It does need to be repaired. I believe I share joint 50-50 responsibility for repairing the property, but because they will not allow access according to the code 3307, I believe that means that the ability and the responsibility devolves to the adjoining property. There's no way for me to remediate that wall if I cannot have access to the professionals that I contract to even come out and inspect the wall.
Okay. All right. That I just wanted to just ask the question. Okay.
Okay.
Thank you.
Can 1721 South 20th Street tell us your side of the story?
Of course. My name is Rob. This is Valen. We're the owners of 1721 South
Hi.
20th Street. We also have Daniel Katz here to assist us with this process.
Could we get the screen share, please?
Yes, Ms. Anderson, could you? Thank you.
Thank you.
Okay.
So first, I want to thank everyone for their time today for allowing us to speak and hearing us out on this situation. We want to present a statement in three parts. First, discussing the survey, which Inspector Rybakowski briefly touched on. Next, we want to touch on the current situation and what blockers we're experiencing. And finally, what we request or hope to get from the board today. So to begin, I just wanted to add a little bit of information and clarity about our survey situation. We've been in close communication with both the 2nd District Surveys Office and Inspectors Rybakowski and DeSabato. The survey office needed to come to our property 5 separate times and perform 5 separate surveys in order to come to the conclusion that they came to, starting last September and finishing up this March. The results of that was that our existing deed is in error, and it's stating that our property ends 5 to 7 inches before the load-bearing wall, which was the information we were operating off of. However, that's actually the conclusion that the first 4 surveys came to. However, on March 18th, the survey discovered that there was likely an error in the deed, and our property likely extended an additional 7 7/8 inches north, meaning that the shared property ends approximately 3/4 of an inch into the wall, which would be the surface or the stucco layer of this wall. And this survey is more recent than the 2021 survey performed by our neighbor. Additionally, the Second District Survey and our title company both have noted and agreed that this error was their responsibility, and they're currently working together in order to correct this with our deed. And although this is not currently our property according to our deed, we have agreed to comply with this notice for permit with the structural engineer drafts and reports and the excavation and remediation of the stucco. Additionally, let's see, we've informed the L&I inspectors of all of this, and we have accepted bids to do this work. We additionally solely financed an evaluation, which we provided here to the board and our neighbor. We put down a deposit for an original stucco contractor on February 12th, but were denied permission in order to perform that work. And we again accepted a new bid on March 27th of this year, but have again been denied permission to proceed. So that moves on to the second section of our statement here, which includes the current situation and what blockers we're facing. Since this notice was issued back in February, we have consulted
so we have consulted with many experts to kind of get to this point. The evaluation that you saw from Inspector Rybakowski actually was financed by us. That's from an entity called MIFAC. Who we had out, who gave us basically an evaluation of what the extent of the dilapidation was on our neighbor's property. So I'm just going to show some pictures. I know that Inspector Rybakowski showed you just what was happening on the surface of the wall. So that's the overview. But let me share my screen really quickly.
Sure.
Thank you so much. Let's see. All right, so included in the MIFAC report, I know that he did have some images to show you, but essentially the problem that we're having is the stucco is on top of a wall that needs serious repair, not just on the surface of the wall, but at a certain depth of the wall. So what we've explained is that our recent survey, our current survey, which is the most current survey as it's been done by the same entity as our neighbor, and they've done it 5 different times. That survey is stating that we own just that surface of the wall. So these are the images of the top of the wall, which I know are included in the MIFAC report, but you can see there's this dark substance at the top of the wall. There are also boards that are holding up this unstable structure on the balcony at the top of the wall. There are also some deep cracks at a depth of the wall. Can everybody see my cursor here?
Yes.
Okay, hopefully. Okay, great. So there's some deep cracks here at the surface of the wall that our experts, structural engineer design and construction, who are which is the entity that our neighbor hired. That is the vendor that we've been relying on to just kind of give us a scope of work of how much remediation needs to happen to the wall in order for us to address the surface of the wall. And they've let us know that it's possible that the firewall here has been breached. It's possible that there's some damage to the interior of the wall.
As well as structural damage.
Structural damage to the wall, and masonry work needs to be performed at the wall. And you can see at this depth, this extends far into our neighbor's property. They've also let us know that they are going to need to do a better examination of the wall, including the interior of the wall. You can see this image is the brick sharding coming from underneath the wall, underneath the stucco. But this entire area needs to be at the top of the wall and the side of the wall needs to be remediated in order for us to address what is on the notice, which is the stucco on the wall. Do you want to continue?
Sure.
Okay.
So that brings us to one of our biggest blocker, which is the communication with our neighbor, which has come to a standstill. She's only communicated via certified letter, which takes up to 5 days to arrive and is extremely untimely. We have requested email correspondence from her, a third party or a mediator of some kind in order to expedite these communications.
Right, we requested that so we didn't receive any, sorry to interrupt you. We didn't receive any communication until February 16th from our neighbor, despite being issued this notice on the 1st. We do have a history with our neighbor that we want to touch on a little bit later, but we then didn't receive, here, go ahead, you go ahead again.
Yeah, so we have experienced long periods of time,
Yeah.
like multiple weeks of no communication, and we understand that this is an extremely time-sensitive
Yes.
situation. And in order to hopefully speed up the situation and communication, we retained our lawyer who is here today. In order to, have a liaison for her to communicate directly with. But since then, she has blocked him via email and ignored letters he has sent. And the tone of her communication towards us has been aggressive and argumentative. And we have been informed by our neighbor that she reached out to a mediation group, but we have received no confirmation despite repeated attempts at trying to contact this mediation group. Additionally, in order to schedule access to our property, we requested 48 hours notice, and as well as timing and contact information for these vendors so that we are able to verify them as licensed and insured entities. But these simple terms, and I think reasonable terms, were failed to be met on multiple occasions as recently as last week. Additionally, due to our past history, the police have suggested us to not engage with her directly. And we have repeated and documented situations of aggressive behavior from her side, which we'd be happy to share with you if you like.
Yep.
And that brings us to what we're hoping. Oh, go
Well,
ahead.
I just want to quickly refute the points that we have been denying entry. Like we said, we're asking very reasonably. We just need to know who's coming, when they're coming, make sure that they're verified. And I can go through each instance of the vendors that were called out who were denied entry because we have had successful communication with different vendors, including the one that we agreed to hire on March 28th and never received Structural Engineering Design and Construction LLC. But we never received any communication to move forward and actually schedule that, which was 22 days ago. So,
Okay. So I'm sorry. So before
Yes.
we go any further,
Yes.
so I just want to ask one question and then
Yes.
I'm going to pose it to the board. So my one question is for your property. You would agree that work needs to be done to this wall and you own a part of the wall, correct?
we agree that we own 3/4 of an inch of the wall, yes. The stucco.
Okay, but it's still
Yes.
owning part of the wall. According to the
Yes.
new survey, according to that, it is a shared wall in some way, shape, or form, requiring work to
Yes.
be done. With that, as the department, I'm going to object to the rest as a relevance matter. It's all well and good building a case record or putting it on record on the dealings between neighbor and neighbor, but ultimately that is not for this board's decision. The board's decision is whether or not the violation is accurate and whether or not there is a variance or a time frame to adjudicate and grant on whether or not they are going to ask for this work to be performed, or at least a permit to be under review. It is the department's belief that a permit be obtained or under review within the next 90 days. That's what the department is petitioning into the board. Again, access to your property, the department can't order one person to give access to another property and therefore another owner to do the same thing. The only thing we can do is say, hey, work needs to be done, and it needs to be done in a timely manner, and if not, then the department can seek a line of enforcement after that time frame. With that, the department's going to rest. I'm going to put it in the hands of the hands of the board, or however they want to do it. But with that, the department rests.
I have one question. Valen and Rob, you said you wanted to proceed to get the wall fixed, but you were
Yes.
stopped. What stopped you? I mean, you have a violation, you have a right to file a make safe and correct it. So what stopped that?
What's stopping that currently is that, well, first, we haven't been granted permission with the shared wall to move forward from our neighbor. And second, we weren't able to get to our final section of our statement, but we were hoping that there would, we're a little struggling a little bit with the stucco delamination and then the actual structural integrity of the wall itself, because we feel that that is outside the purview of this notice. And we're just trying to, shore up this notice for the board here.
Right.
But meanwhile, we're concerned that there are structural issues with the wall that go beyond the scope of this notice and additionally are not within our ownership and not within our property line. So we were hoping that the board could maybe have additional citations or amend this notice slightly in order to kind of separate those two things for us. That was the goal of our statement, was to get to that point.
Yes.
We may want to address your second comment there, but just one thing I'm wondering. At this point, the entities that Ms. Anderson wanted to have access to your property in order to investigate, have you had a chance now to evaluate their credentials and approve them so that if it could be arranged for them to come and follow through and do that inspection? Are you willing to allow that to happen? And can we help facilitate the scheduling of that? And again, all of this is pointing toward a resolution of all this being done within the 90-day window that Tom's recommended, which I think I can't speak for the others, but I think that seems like a reasonable time frame to have it all done, assuming everybody can move forward together. So are you comfortable with that?
Yes. So we have allowed people that she selected to come into our property and observe the wall. The issue we're running into is timeliness and ability to vet these people, because we're not necessarily in a place where we're trusting of each other to, provide, vetted people. So with the Structural Engineering Design and Construction LLC, that was a vendor that our neighbor selected, that we've been in communication with, that we've achieved and gotten a bid from, that we find is reasonable. And we've gotten other bids that ourselves independently, we've had multiple bids that we've discovered that we've shared with her. And the issues are that just with these past few that she's claiming, she has not communicated to us that they're coming, and we're not in a position to just drop everything and let these people into our house when we're unaware of it and not able to do it.
Could I also supplement,
please?
could I also supplement for the first entity that our neighbor is citing that she's saying denied? If you look at the letter that she sent, we're not being given all of the information we're requesting. So she didn't tell us the entity, she didn't give us the phone number, and she's giving us vague information. She's saying they'll come in the morning. That individual came at 5:30 at night. We waited all day for him. And it's at the gaze of how she's presenting it, it sounds like we're denying access, but we're being perfectly reasonable, asking for communication faster than every 5 days. If we get it, we've had large sections of time where we've had no communication at all, which we've explained to Inspector Rupakowski. So we are trying to make this notice good. We've also hired another party prior to this. We accepted a bid back in February, which our neighbor did not consent to. So we are actively trying to make this good, but we just keep getting blocked by the fact that there is no communication happening.
And we've had 6 separate contractors and engineers evaluate this at this point. So we feel like that's a reasonable number and that it's time to move forward and stop kind of churning on this.
And being argumentative
Yes.
and
be heard.
Okay, Ursula, go ahead.
Thank you. I have requested documentation from all the professionals that they claim have evaluated the property and given bids and deposits that they say that they have put down for any contractor. They have provided zero, no documentation.
We have provided
It's my
them.
time to.
Hold
It's
on.
my time to speak.
Let her speak.
They have
Go ahead.
provided no documentation at any time, and I have requested in letter after letter, month after month. They say they've gotten these bids and they simply won't provide the information. The other thing is that they started communication via certified letter, and I have simply followed suit. They have actually forbidden me to or demanded that I stop sending them letters and only send letters to their legal representative, which means that there is a huge delay between our communication, but it's only because that's the method of communication that they have established, and I have simply continued with that level of communication, especially since this whole issue may be landed in civil litigation. So there is no way for me to not deliver communication via certified mail to make sure that they get these letters. The last letter I sent for the company that was coming on Thursday, I sent them a letter and a week and a half in advance of the person coming with their name, their phone number. And I've done so for any person or business that I've contracted. I have given them name and the phone number, and they still they act as though that they haven't had a chance to vet any information, and they haven't done the same for me. They've given me no names, no numbers, nothing for any of the people that they say they have contracted or put deposits or whatnot. I haven't had a chance to vet any of those people or see anything or talk to them. None of it.
One
Can
thing.
I speak here?
Actually,
Real quick.
Yeah, go ahead. Everybody's gonna get their
I-
chance to speak and then we're gonna make a ruling on it. So if you have something to say, say it. Go ahead, Counselor.
I just wanted to note, I initially sent a letter to Ms. Anderson back in October, informing her that my clients had noticed the issues with the wall and they were trying to be cooperative and collaborative in order to get the repairs fixed, because at that time, nobody was sure exactly whose property was whose and what was wrong. We did not hear back from Ms. Anderson. In every single letter that I have written her, I have asked her to reach out to me directly and provided contact info. She has not done so. And then, as my client said, she actually chose to block me on email after I contemporaneously sent my last letter to her via email as well. So I'm not sure that's a fully accurate portrayal by Ms. Anderson as to how communication has been.
I have a question for
Okay.
maybe for Mr. Rabakowski, possibly for Ryan McSherry. The comment that you're responsible for a certain piece or amount of that wall based on, I assume, the location of the property line. Is that strictly true? If a wall is determined to be a party wall, as this has been, is there equal responsibility for that wall in terms of its structural integrity, or is that proportionally shared depending on where the wall sits? Any insight on that?
So as far as the department is concerned, it's a shared wall. So it is the responsibility of both owners to make the repairs to the property. Depending upon how much that is and who recoups financially between and puts out the money according to where the property line falls, that's a civil matter between property owner, and who facilitates the repairs. That again is between property owner and property owner. At the end of the day, the department is just looking that this wall be made safe and that it is done under the guisement of an issued and approved permit.
Could we actually just take a brief executive session just for a moment? Ask the board members to join me in the breakout room.
Well, can we make one more point before you all do
Okay,
that?
go ahead.
So like we said, we've already accepted a bid from a vendor that our neighbor brought to us in an effort to make a reconciliation here. We haven't heard anything about it since March 18th. I don't know why we're not hearing anything from our neighbor about it right now, because we accepted that bid. They said that they were ready to do the design plans and do the make safe permit and move forward with making the wall safe.
I'll-
So
Yes, I can address
didn't-
that. I sent a letter to you saying that in all my letters, I have specified that like the website, the license and inspections, their recommendation is to get 3 bids. And so I have always said in all my letters that we need to get more than 1 single bid on a property, on the work. Your bid that you keep mentioning is from a stucco contractor. I don't know. I've looked at that person's credentials. They have never performed structural repair work. Yet you want your your stucco contractor to do this work. And that is not acceptable. I haven't, and so this last, my neighbors did give access for 1 group to come and inspect the wall. I found out later because the individual, the company that did the bid and came out, that they had spoken with this individual and told him that they were only responsible for the stuccoing of the wall, and that they were trying to reduce the amount of money that they were going to pay for the wall instead of it be 50-50. So that individual, that company, by mistake, sent me an invoice, 2 invoices, where your amount of payment was reduced by $8,000 and mine remained the same. And when I spoke to him, he said that you had reached out to him to try to reduce the amount that you were going to pay.
All right, let's go with the administrator. All right. Okay. Here's our decision. We can't get involved in how you guys deal with each other. We're gonna take the recommendation of L&I. You have 90 days to get a permit and make safe. That's it. Work it out, whatever he's gotta do. All right? Thanks very much and good luck, and hopefully he's get it done amicably. Okay, thank you.
Thank you.
Bye-bye.
Thank you. Bye.
Okay. That's those 2.
Mr. Miller, just as a point of reference, the appellant for number 3 indicated that they may not be able to attend today. We advised them that as the case was a dangerous case, that they would have to appear today if they were going to ask for a continuance, but they, as of right now, have not responded back. to us.
Okay, we'll make our decision.
Okay.
We ain't worried about them. They're supposed to be here, they're not here, that's our problem.
Yes, sir.
Okay. All right, number 3, 3333 Rand Street. Okay? Is anyone here from 3333 Rand Street? Going once, going twice, going 3 times. Deb, is there anybody else in the secret room or whatever?
No, we have no other people waiting.
Nobody else is in there. We will continue with the case, all right? I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Ryan McSherry, board counsel. And just before we continue, I just want to know if I could just have Mr. Amato just confirm that notice was sent to the appellant. Just if you can confirm the date that notice of the hearing was sent to the appellant and at what address.
Give me just a moment. I'll have to look that up, but yes, we did send it.
Okay.
Emails were sent to the appellant for Rand Street,
Okay,
back and forth, because that's how she gets her information. She did respond to Phil.
Okay. Was
and then
the
he responded back.
was the notice only sent via email or was it mailed as well?
We send emails by emails. We send notice. We send
Notice
them
by
by
email.
email.
Okay.
So the original one I originally sent, I don't know if Phil would have that or not. So I sent that out back in, maybe you do. Isn't it attached, Phil?
I showed
Right.
that on 4/4, I sent an email confirming the hearing date for today and that her presence was required and expected at this hearing.
But I sent her an email back in February giving her 2 dates, April 4th and April 18th. So
There's a signature here, on 2/5/24. The appellant's signature, did she sign for this? Or they signed for this? That they received it? Is that what that
she signed the
means?
appeal.
Okay,
I'll go back and look for my email.
All right, why don't we move forward with Mr. Radikowski's?
okay, we'll move forward. Okay. Again, do you want Wayne Miller, board member?
And your Rivera board member.
Ed August, board member.
Brian McSherry, Board Counsel.
Philip Motto, Board's Administration.
Deborah Richardson, Boards Administration.
Okay, Tom.
Thomas
Tom.
Radikowski, City of Philadelphia License and Inspections.
Okay. No one has showed up for this case. They were told to be here and it's a dangerous case, so we're gonna proceed with the case. Tom, could you please raise your right hand, swear to tell the truth, nothing but the truth?
Yes.
Okay, Phil, could you read this into the record?
Yes, sir. This is MI 2024-002-223 for the property located at 3333 Rand Street, R-A-N-D. The appellant is Gina Battaglini, B-A-T-T-A-G-L-I-N-I. Email correspondence was made with the appellant as late as April 4th, confirming the date of the hearing and the time and the expectation that the appellant would be here. There is no appellant in the room. There's no appellant by that name in the waiting room either.
Okay, Tom, could you tell us about this case?
So in January of this year, January 24th of 2024, the property was deemed as eminently dangerous following an inspection that occurred for a tree growing in the exterior wall of the property. I will share my screen and show photos
Please.
of the property. At the conclusion of my opening, I would be asking the board to deny this variance in its entirety for failure to appear. If the board decided, then we would ask for a make safe permit to be obtained within 10 days. But it is our belief that it should be denied for failure to appear in its entirety. But I will show photos in the case record of the property. Can everybody see my screen?
Yes.
Yes, we can see it.
Okay, so this is the front of the property at 3333 Rand. This is the posting that was affixed to the plywood that was over the.
Is that a corner property, Tom?
It is in the middle of the block, but it is banked on one side by a vacant lot, and you will see that in
Okay,
some more.
sorry. Okay. Go ahead,
This
Tom.
is the side lot of the property. This is the rear of the property. There is a vacant lot with a semblance of a tent. Photographs were taken back in January 24th of this year. This is the side wall where the tent is set up. You can see that the opening of the brickwork right here. And this is another photo from the rear of the property. And I'll go to the bottom of the document, and it shows the photographs a little bit better. And I'll zoom back out. So that's the front of the property. That's the posting. That's the back. This is the most concerning. This is the side wall of the property. You can see that it is completely, there is a tree that has taken root from the roof line all the way down, and it's opening up the base of the sidewall. With that, I'll rest, and I will ask that the appeal, or that the the appeal that's been filed be denied in its entirety for failure to appear.
And I
Oh,
went back to check my emails. I'm sorry to interrupt. An email was sent to Rental Phillies Properties, which this appellant, she owns this business, March 11th, 2024, with detailed information regarding, I'll send it to everybody if you want to see it, with 2 dates, paying the $50 fee, all the information, and I headed it with, please forward this email to Gina Battellini, so she would have the email. So Phil was emailed, I emailed, Phil got a response, and we emailed her back. We told her it was being scheduled. I cannot keep holding up cases that are ID. They have to move forward, and I did give her an
You're fine,
option.
that just.
I know, I'm just letting you know, so it was March, back in March.
Just want to have it on the record that she was notified.
Okay.
Tom,
Okay.
one question.
right.
Minor thing. It's hard to tell from the photographs, but is there a portion of the building that is fully intact, or is and with simply the back of the building, you know, separating from the front of the building, or is it entirely compromised in your opinion?
So this is deemed eminently dangerous, showing that there is a tree that's essentially taken root in the width of bricks in the exterior wall, and it appears to be the side load-bearing wall towards that vacant lot. So potentially, if we lost that wall, we could lose the structure.
Okay, Mike. Question is that house next door occupied there?
Let me go to the photos. I can go to the first one.
I'm gonna note, I was just looking on Atlas, and it looks like it's been a vacant property since at least 2012. And it's been receiving violations about being a vacant property for a long time.
Is there somebody occupying that house, Tom?
In looking at the photograph of the front of the property, it does appear that the property to the right, at least is maintained. It could be occupied.
Okay, it's imminent danger, right? They get a permit within 10 days or take it down. Anybody have a problem with it? Aim, Ted? 10 days, they should get a permit and then make safe. If not, take it down. Okay,
I'm just gonna say 15 days for 2 weeks.
no, 10 days. I'm not, no, 10 days. She's had stuff since 2012. 10 days or take it down. That's it. I mean, this is a pandemic in here. They get these houses and they just let them sit and let them rot. And how would you like to live next door to that? That's a disgrace. So take it down if it's not done in 10 days. It's just, it's a disgrace. It's a disgrace. How about that neighborhood? How about that person next door? How about the people across the street that have to live around that stuff? Okay? And since 2012, it's been like that. You like to live in a neighborhood like that? I bet you half the people, every person that live around there don't want to live around there. And we're going to be nice to them. 10 days, take it down. That's it. Things got to be right. Everybody wants to give somebody that pacify people to do things wrong. Time is running. Take it the freak down if it ain't done in 10 days. All right, that's it with that one. Thanks, Tom. The problem with the city, give this guy a break, give that guy a break, give somebody else a break, and torture everybody else around them. That's a disgrace. Okay. And
Mr.
then
Miller?
Rand Street. All right, it is 1106 to 1108 North 40th Street here.
Mr. Miller,
Yes,
that item was withdrawn. Can I read that one in for the record?
you certainly can.
Sir, this is MI 2024-001-779 for the property located at 1106 through 1108 North 40th Street. That item has been withdrawn from today's calendar by the appellant. That brings you to
Has-
item number
has
5
that
on
item
today's
been-
list.
Has that item been resolved?
Where's
The,
Tom?
the underlying case, I do not know, just the appeal itself has been withdrawn.
No, Tom would, I'm asking because it's imminently dangerous and the appellant withdrew it, which doesn't
The
make sense.
appellant
to me.
withdrew it. The appellant withdrew it for, I can't speak for them, but they have a permit under review for the demolition of
Okay.
the property.
Okay, you say they have a permit under review. When they pull that permit, they have to start on it and make it safe until it's made safe. Am I right?
They have to, under the provisos of the property being deemed as eminently dangerous, work must start within 10 days. So they would have to, so essentially demolition would have to be within 10 days of that issuance.
This is on the one that's been withdrawn here.
Correct.
Yes.
Okay, so they have to start within 10 days and have a permit.
Once the permit is issued, there is a permit under review. There was update as of yesterday by the reviewer. I do not know as I did not pull it because the appellant apparently was withdrawing for today's hearing. So
Okay,
I
do
don't
they
have all
withdraw to get away from something, to get a longer period of time?
No, so as long as a permit is active in our system, we will not go by any enforcement and essentially demolish the property. But if that permit was abandoned for any reason, then we would move ahead with seeking an enforcement against that owner all the way up to demolition. But
Okay, let me ask you a question, Tom. If I pull a permit on something because I pulled the permit, okay? Then the 10 day, it could be 20 days before he starts, 30 days, is that right?
No, so once the permit is issued, work must start within 10 days. If they
Okay.
do not start work within 10 days and the inspector goes out there and work is not started, the inspector has the option of calling the contractor and saying, hey, what's going on with this? Or expiring it outright. But
When was the permit pulled?
permit hasn't been issued yet. It is under review by the department, meaning that they are being asked to provide additional information. But being that a permit is under review, this board, it's whether or not the violation exists and whether or not we're granting a variance time to obtain that permit. Well, they've already done that. They've already said that they agree with the violation. They wouldn't be applying for a permit if they didn't agree with the violation. So essentially, they're agreeing with the violation. Secondly, by asking for a variance in time to get the permit, well, they're already in the process of getting the permit. So there's no need for a variance in time because they're already under the process of getting a permit.
Who's
So-
reviewing the permit?
I don't have the exact name in front of me. I believe it
Is it
was
somebody from L&I reviewing it?
Oh, yes, it's in the hands of one
Okay.
of our plant examiners.
Okay.
Yeah.
All right. Now, does this take precedent? Does it move up in front of anybody else so they can look at it?
It's an automatic 5-day review period because it's deemed eminently dangerous.
Okay, so again, when did the clock start ticking?
I'm not following on when did the clock start ticking.
Okay, if it's 5 days for the plan examiner to look at something that's dangerous, when did this get sent to the plan examiner to review it?
I have that the permit was applied for on or entered into our system on April 10th, and it was reviewed with a request for additional information, which was provided, and that was completed on again the 10th. And there is assigned to another department representative with a update in the system that should have been completed as of yesterday. There is no update in the system for today. But essentially the permit could be issued and should be issued unless there's additional information that is required. That additional information must be provided back to the department within 10 days. If not, then the permit would be abandoned.
So what are we talking, the 28th?
Let's see.
Today's the 18th.
So one. So that would be 10 business days. So that would be May 2nd or May 1st.
Okay, now what happens if nothing's done by May 1st?
If nothing's done, and then the permit application would be abandoned, then yes, the department would send out a notice to the owner, and making them aware that, yet the property was potentially being placed to bid by demolition by the department.
Okay, could you let us know in May if that's the case? And
Sure.
if they don't comply by May 1st, go ahead with the demolition contractor and take it down.
Well, I can't say yes or no because they withdrew their appeal, so there's really nothing for the board to order, but I will certainly let you know how it turns out.
Okay, so but by the 1st of May, right? That's what we're talking.
Potentially by the 1st of May, we would know whether or not this permit was abandoned or whether or not the permit would be issued.
Okay, and then could you let us know?
Absolutely.
Okay, and then do what you have to do according to them not doing their thing. You send the contractor out there or let them know it's going to come down.
We would take the appropriate enforcement action needed.
That's great. That's great. Good, Tom. Thanks.
Okay.
Okay. Number 5, 5340 Sherwood Street. Is anybody here from Sherwood Street?
Mr. Brady, you're on mute. You have to unmute yourself on your phone.
Brad, you can't hear it.
Yes, Brad Brady, I'm here.
Okay, Brad. All right. You're the only one here, Brad?
Yes, I am the only one. My brother, he's busy today. Yes, just
Okay,
me.
I just want to swear you in. Please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth.
I do.
Tom, can you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
Yes.
Okay, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted Igus, board member.
Come on.
Ryan's trying to unmute himself. Debbie
Oh,
Richardson,
okay.
Boards Administration.
Sorry, Ryan. Deb, how about you?
Sorry about that.
Boards Administration.
Yeah, my computer froze. I was trying to unmute. I apologize. Ryan
Okay.
McSherry, board counsel.
Bill,
Right, Deb.
Philip Motto, Boards Administration.
Deborah Richardson, Boards Administration.
Okay, good. Bill, read that into the record, please.
Yes, sir. This is MI 2024-002-210 for the property located at 5340 Sharswood Street, SHARSWOOD. The appellant is Brad Brady. He's present in the room today, sir.
Okay, Tom, do you want to speak first, or do you want to let Brad speak?
I'll go first.
Okay, good.
So essentially what we have is we have the property at 5430 Sharswood.
Can we get that straight for the record? This is 5430 and not 5340.
This is
I have 5340.
But all the paperwork says 5340 and I think it's 5430.
It's 5430.
Okay, thanks, Brad. 5430?
Correct.
Okay, good deal.
5430?
5430, 5430, not 5340. Got it, Deb?
Correct.
Okay. All right, Tom, let's have it.
All right, so this is for the property at 5430 Sharswood. property was deemed eminently dangerous back in December of 2021. The property has changed hands through transfer deed or property sale to different individuals. There was a make safe permit that was issued on this property. That permit was issued with an inspection taking place approximately on March 9th of 2023.
Ryan, did you own that then?
I did not.
Okay, good. Go ahead, Tom.
So when that inspection took place, there was concerns with some of the material or some of the, there was requests of additional work that needed to be done or additional requirements by the inspector of that entity who had that permit. It became knowledge to the department by way of speaking with Mr. Bradley that the property changed hands and he was the new owner of the property. That conversation happened on or around March 22nd of 2024, where communication was provided that they became the new owner of the property. That said, we sent a notice indicating to Mr. Bradley that work needed to be done to bring this property into compliance. The make safe permit was expired, requiring, and in that communication with the department, in fact, it was me, I made reference that an engineer's report for the work that was done to the property and the work that needed to be done to the property needed to be obtained, and then a new make safe permit needed to be issued for the repair of this property. I will share my screen if need be to show what this property looked like at the time the property was deemed as eminently dangerous. It was conditions with the rear.
Tom, was there any work done on it prior to Brad buying it?
So I have that there was work that was done, but it wasn't completed and the permit was never closed. So that's what brought the permit to be expired. There was no property cert that was pulled on the property. The appellant is making the information or the reason for the appeal is we were completely unaware of the violation and dangerous conditions of the property before purchasing. We need more time to invest money and responsibility for repairing the building without any fines or penalties holding us back. It's our belief that the property does need repairs. It needs a new make safe permit. It needs a new evaluation by a design professional, by an engineer on what needs to be done to bring this property up to a safe condition under the guisement of a make safe permit. Because work has been done, we are willing to allow 60 days to get a permit under review. I'm not looking for a permit to be issued and work started. I'm just looking for one to be under review by the department within 60 days. The last, I'll share my screen and show you the photos that we have in our database for what this property looked like when it was originally declared, or when it was declared. Everybody see my screen?
Yes.
Yes.
So this is the appeal paperwork. And then this is the photograph of the rear of the property.
You flip that around.
There.
Okay.
So what you have is you have this property here. Basically, the rear bay is open completely. This was done December 8th of 2021.
Yeah, it looks completely. Do you have on your records that they demolished the house next door to my property as well?
I do.
Okay.
And that would be because the property next to you was also deemed eminently dangerous.
Understood.
In fact, I did do an inspection on the property in February of 2022 and issued a stop work order onto the property. So I was personally out at the location. And at that time, that's this photograph showing and illustrating the work that was being done to the property without the permit. We did make reference and they did, like I said, they did obtain a permit, but they never completed everything that was required on that permit.
Were they fined for not having a permit?
There was a stop work order, so there are fines and fees that are associated with that stop work order being issued.
Okay, go ahead.
So essentially, we're asking, and because there is work being done, we are willing to go the 60 days.
Brad, tell us what you're doing to do, pal.
All right, so yeah, that's all fine by me. So I purchased the property March 8th of 2024. I was never under the impression that, there was to make any violations on the property, nothing like that. This is my first investment property that I purchased. And I had a plumber go to try to pull a permit. His permit got kicked back. That's how I found out there was violations. So that's when I reached out to Tom and to the city. And I just did it. He sent me an email and I had to obtain the permit by April 5th and it was March 22nd. So I have no problem with getting the work done, whatever has to be done, I just never been down this road. So I just didn't know what to do. So I made the appeal. I want to get the work done as soon as possible because I got $40,000 just sitting there, So yeah, I'm whatever I have to do.
I got it.
I just don't know exactly what I have to do, so that's why I'm here today. And the only reason I did the appeal was because I just felt like I didn't have enough time in 12 days to get an engineer there, get plans, get them on the city's table, get them approved, and get somebody to come in and do the work,
Okay.
So,
Tom, could you tell Brad exactly what he has to do? And you have 60 days to get a permit.
yeah,
Okay.
that's
60 days
great.
for a permit to be under review.
To be under review, I'm sorry.
I want a permit under review in 10 days. I want to get this on the ball.
So essentially, what you have to do is the violation notice that I sent to you. Engineer needs to visit the property and address all the violations that are on that, address all the named issues in the violation. If they come up with any others, then it can be addressed for the make safe permit.
Okay.
But essentially, any work that needs to be done under the make safe permit. The
Okay.
permit gets issued, work must start within 10 days of that permit.
Okay, now I do have one more question. So, since I was told by the neighbors about 6 months ago, the house next door was demolished, and there's a whole new roof on the property that I purchased. I mean, it's all new roof joists. There's new plywood. It's a whole brand new roof on that. The back bump out that you pointed out in the picture, that's all framed out. There's all new sheathing on the second floor. So I just don't know if there was a permit pulled for that. I just don't want to get jammed up like I did that work. When I purchased the property March 8th, when I went into there the first time I was in there, I've been down there one time. All that work is like brand new work. I didn't know if that was done because of whoever tore down the house joining my property now. They damaged the roof or something because there is a whole new roof. The whole entire roof system is brand new on that property.
So that's why we are saying that the work that was done to the property needs to be illustrated in that report.
Okay.
As long as it addresses that the violations for the make safe.
Okay.
If
And
there's
who would do
additional-
that, Tom? Would an engineer do that? Come out to the job?
Yes. If there is
And-
additional work that needed to be done for, is the property completely renovated or is there more work that needs to be done?
No, so the house is literally a shell. It's 4 walls and 2
Oh.
floors right now. That's all you got.
All
But
right, so
as far
essentially,
as the make safe permit's concerned, you're gonna get a permit that will in part be for work that has already been done and in part maybe for work that has not yet been done. But it'll be everything, as Tom's saying, that is addressed in the make safe, I'm sorry, in the violation notice.
right. And then all the other work that was in there, you can get a building, a alteration permit for all the other work. Now, let's say the engineer comes out, goes and takes a look at this property and says, you know what? All the work was done. Great. Looks great. They can send me that report. We can comply the unsafe case or the eminently dangerous case to that report. And then that would allow you to get your alteration permit for all the other work that needs to be done.
Okay, yeah, because I had a plumber applying for a permit and an electrician, and then the plumber called me back one day, and then the next day the electrician called me back. He said, "Yo, the permit's got kicked back because of make safe violation." All right, so I just got to get an engineer down there, get him down there, get my make safe permit, and then the engineer will basically make me plans, get them on your table, and then we take it from there.
Essentially, the engineer comes out to the property, takes a look at the property, comes up with a means and method on repair if it is needed. If it is not needed, send me that report. Then your plumber, your electrician, your contractor, or your GC can pull the alteration permits and the mechanical system permits accordingly, and they can do that online. The reason it was kicked back was because the property was deemed eminently dangerous and it's considered a structural repair, and it requires an appointment to come into the building. It will not
Okay.
allow you to apply for them online. That's why
Okay.
your plumber and your electrician were getting a kickback.
All right,
Just a
awesome. Fair
question.
enough.
Out of curiosity, when you bought the property, was it a private sale or was it sheriff's sale, or how did you acquire it?
So it's basically from like a wholesaler. My brother's a UFC fighter. One of his buddies does like wholesaling houses, and he had the property. I guess he had a contract with the owner, you know. So we bought it. Yeah, it was basically like a wholesaler.
Yeah, well, the reason I'm asking is, did you get a title, was there a title search and title?
Yeah, there was a title. So I'm sitting here looking at my stuff right now. Yes, there was a title search to make sure everything was cleared on the property. And that's another thing I'm dealing with right now. I don't know why that still wasn't disclosed to me at the closing table.
The violations weren't in there, so you're saying, so that's, yeah, I mean, that's.
Yeah, no, the violation. I mean, it hit me by surprise, you know, because the property looked nice. It looked like it was decent shape. You know, I got down there, cleaned it out a little bit, sent all the information to my plumbers, the electricians, got bids, and I was ready to get on the ball, you know, and then boom, it got kicked back like that, and it hit me by surprise. And, you know, so I have some people tell me that, you know, they don't have to disclose that at the closing table. Then I have people that tell me that it does have to be disclosed at the closing table. So I'm speaking to my lawyer, but yeah, I mean, at the closing table, I wasn't aware of nothing like that before I bought this property. I didn't even know about the Atlas program, you know, like I'm a masonry contractor. I do masonry work. So I'm trying to get into the real estate, and so it's a learning curve, you know, but now I know about Atlas. I know about these programs where you can look up violations, but previous to this, I had no idea about none of it. I was never informed of it. They just took my $40,000 and give me my deed and on my way.
Well, just
and then Tom sent me the email. It's like March 22nd. It's like, you got till April 5th and you're being fined $2,000 a day. I'm like, damn. I'm like, I messed this up big time, man.
Yeah. Just make sure that.
I was like, man, I was double thinking the whole thing. I'm like, man, I don't know what I got myself
I'm
into.
getting out of the real estate business. Boom, I'm
Yeah,
staying
yeah.
with the masonry business.
Yeah, I was going to go lift up some more concrete.
All
right, so
it'll work
I
out well.
actually do have an engineer. I have an engineer scheduled. I scheduled him like 2 weeks ago. He was a month out, so I should have an engineer down there within 2 weeks. I'll get him down there. I'll have him send you over the paperwork to Tom, and then yeah, I guess I'll just take it from there.
And just make sure your subcontractors are, you know, all registered with the
Licensed.
city so that you don't get in any more trouble.
Yeah,
So-
no, they're all registered. They're all registered, all licensed, and the whole
Okay.
9 yards.
Good deal. All right, Brad, good luck, man.
All right, thanks, guys. Have a
All
good
right.
day. I appreciate it.
You too. Take it easy.
All right, bye-bye.
Bye. Tom, that relieves you, right?
That's it for me. Have a good one.
Thanks, Tom. Appreciate it, pal.
Yep.
All right.
See ya.
Is Dimes here
Take
yet?
care.
Yeah, I'm bringing them in now.
Bring him in. There he is.
There are 10 appellants present in the room for the remaining 3 cases.
10 appellants? Okay, no problem. All right. You there, Dimes?
He was and now he's not.
He'll jump back on. Okay. What's
Must
the
have
next
got
one?
bumped out.
Would you bump him out then?
I didn't bump him out.
No, I'm only kidding you.
He'll join
Do you
back
want
in.
to stop the recording until we get everything in order?
Yeah, you don't have to record. Could you put the recording on, please?
Okay, so you can stay here, you can go back to live here.
John,
Matt,
the
are you
recording
muting
on?
yourself?
The recording is on.
Your recording's on?
Yes, sir.
Okay, fine. Okay, so, Josh, there's just you, Justin, and Matt, right?
Correct.
Okay, Justin, could you please raise your right hand? Swear to tell the truth, the whole truth, nothing but the truth?
Yes, I do.
Okay, Matt, can you please raise your right hand? Swear to tell the truth, the whole truth, Nothing but the truth?
I do.
Yeah,
Could I
Josh, you're
please
a
have,
lawyer,
excuse
right?
me, I'm sorry, could I please have their full names?
Okay. Matt and Justin, give your full names.
Justin Lucas, Lucas. Matthew Davis, Davis.
Okay. Josh, you're a lawyer, right?
Yes, sir.
Okay, we don't have to swear you in. Okay, Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
John Dimes, Fire Code.
Ryan McSherry, Board Counsel.
Deborah
Amato, Boards
Richardson, Boards
Administration.
Administration.
Phil
Matthew
Amato,
Ojic,
Boards
LNI
Administration.
Supervise. We need to have an order.
We do. You mixed it up, Matt.
Oh.
We had an order. Okay, but here's how we'll go. Phil, you signed in, right?
Yes, sir.
Okay. Could you place that into the record?
Yes, I can. This is MI 2023-006-904 for the property located at 1904 North Second Street. Joshua B. Horvitz, Esquire, is the appellant. He's present in the room today.
Good. Whoever's going to present the case, go ahead.
Thank you. If you don't mind, I'll share my screen.
Absolutely. Go ahead.
Thank you. So this is just to show the plans. We've been here before, but just a brief recap to make sure everybody remembers. My client, Justin, purchased the property in 2023. He was told by his realtor and the realtor on the other side and seller and everything that it was, everything was zoned appropriately. And he actually looked into it and saw, it's the zoning district would allow the use. It's a commercial beauty salon on the first floor and 3 apartment units upstairs. And he bought the property, went to go get a rental license last year. And at that point, after he bought it, and he went to get the rental license, he was told he needed a zoning permit. He went to get a zoning permit, which he was able to get over the counter, and we got that. But when he went to file for the building permit, the prior owner had made these changes years ago, before the 2018 International Existing Building Code, and there were changes, and maybe some of the other configurations existed such that there was a refusal issued, which we asked for so that we could come here and ask for your discretion. The big issue is fire sprinklers, but there's also some smaller dimensional interior differences from the current code, which we've discussed here before, and I'll quickly go over, which are, a narrower hallway on the first floor and a narrower doorway, all very slightly, and a narrower hallway on the second floor. And then on the third floor, we're going to close off a closet, and there's also a slightly narrow doorway there too. So those are the issues, and basically, when we've been here to present before, you all were understandable, or were understanding of my client's situation, that he was innocent in buying it, and he knows better now, but he's stuck in this situation. And you had asked, though, for us to make sure before you would give us a variance that the electrical system was safe. And I'll pull up just a chart of of all the items on the refusal here. I'll pull up the refusal itself. But just to tell you, we came back and last time, and we had some information about the electrical system, but we didn't have our electrician with us, and there were still open questions. So now we're back, and today. So here's the refusals: fire sprinkler. Now there is a fire alarm already, and these slight differences in means of egress and stairwell, and I summarize them on a chart here just for everybody's ease of viewing. That we're talking 2-inch difference in the common hallway, a 6-inch difference on the one door, and 2-inch difference on the other hallway and the sprinkler system. And then we're going to close the closet. So lastly here, I have our electrician with us, because if you guys have any questions, he put up, he went out, he looked at the property. We understood that the board is understandably concerned that the property would have safe electrical system. Since there's no electrical permit required here, we are simply, and there's no work proposed, we're simply asking to get the change of occupancy because of it wasn't done in the past by the prior owner. We're not actually changing anything. So, but we're proposing to change this stuff for the electrical system to prove good faith to the board, and my client definitely wants to make the system adequate and safe for everybody who lives there and the commercial unit. So there was testing done, and because of that, the electrician who's here to answer any questions says they're going to remove the existing panel in the basement and install new breakers and a new panel, and upstairs a new panel to accommodate everybody. And then they're also going to run the hot water heaters for the upstairs onto their panel, so that the upstairs is all in one panel, the downstairs, which is the commercial, is all in one panel. And he says service will be sufficient, more than sufficient, and that, while we discussed separate metering in a perfect world, it would cost $65,000 or more. And, and it would require basically pulling down all the walls of all the work that was there. And these units are, occupied, and they're nice looking, just to show you some pictures from our plans. There were nicely done renovations, with the changes proposed by our electrician, should be more than adequate, and safe. And, so because there's, because this condition existed for a long time before my client purchased, we're asking for your discretion today, as this new code came in the meantime.
So you're saying you're gonna make upgrades, but it still won't be the code?
Well, we talked to our electrician, and he's here. I basically said to him, all right, so what do we do to make it up to code? And he said, well, you can't, first of all, he said, what code? And we talked to him about it, because we're not actually otherwise, he wouldn't otherwise need an electrical permit. So what, basically they're doing everything but making them separately metered, which would be this prohibitively expensive in this situation. It would be more than the actual fire sprinkler system that we're asking for the variance from. And there's otherwise not even electrical permit needed, but, we want to do this work and make sure it's, what the board wants here, and, and safe and adequate for the people that live there.
Did we look at the certification? Is the contractor a licensed contractor, the electrical contractor in Philadelphia?
Matt, can you answer that question?
Yes, I am. My license number is
I don't even know your number.
051603.
That's fine. Okay, just long as yeah. And what last time you came in, what did we tell the folks here? What did we say to them?
So there was some question as to what the code was. There was somebody from the city who was here, happened to be here for another matter, and mentioned what the code was. We've since talked to our electrician, and he told us, well, that's not exactly right. But what he was saying was that he needed these 100 amp panel and another 100 amp panel, which I think is what we're proposing here. But you had said that you wanted us to make it safe and adequate and that comply with the code. And we are basically able to comply with the code, everything but this separately metering, which would be prohibitively expensive, because we'd have to basically tear down all the walls to rewire the whole building in order to do it, and everything's already renovated by the prior owner and occupied, at least the residential occupied.
We had also talked about the fire alarm system being code compliant. Has that been verified?
Yes, so we have a fire alarm certification. I'll pull that up right now.
Okay.
Fire alarm cert. We're kind of at a between a rock and a hard place here, and that, no work is being proposed. Everything that experts are saying are safe, and adequate. And we want to do these upgrades to ensure those things, are very safe and very adequate. But the cost just makes no sense and that's why we're here asking for your discretion. It just makes no sense to pull down all the walls, rip out all the electrical work, put in all new work. It's such an extraordinary expense. When otherwise, if we weren't needing the variance from these kind of minor technical issues that cropped up in the meantime, we wouldn't need to get the electrical permit at all. In order for my client to make this property work, he bought it as an investment. This kind of the electrical requirements of the board, which are not what L&I is demanding from us, is, going to not make it work for him here, and as an investment. It's such an extraordinary expense that it would be. Of course, eventually somebody will, if they make further changes, then in the future, and the walls came down, then that would be a good time for this kind of thing.
I have a question for Matthew Wojcik. Matthew, do they need to be separately, all the units need to be separately metered?
So my
Matt,
belief
sorry, Matt.
is
I'm
that,
asking the plans
different
examiner
Matt.
Matthews.
oh, sorry.
That's
Sorry.
okay.
It's okay. So separately metered as far as like electrical is concerned, because I think Pico is very specific about their whole thing where they only want like one electrical service per property. Or like they only want one like service line into the property, I believe. It's something like that.
So
Where
it
I
doesn't matter if they're not separately metered?
Could people turn off the,
I
sorry,
think that
you guys go on mute if you're not, somebody's got.
Matt Davis, we put it on your.
Davis, you
on
gotta mute. Thank you. Oh my God. So I'm not all that familiar with electrical. I think Josh mentioned that there's happened to be somebody at the last time this came to the board that was more knowledgeable about electrical work. That was just a crapshoot. I'm not.
Okay.
So I can't tell you why all this electrical stuff came up. I'm not seeing anything about electrical work at all on the application, nothing about that, nothing in the comments about it, not on the refusal. So I honestly can't tell you how all that like came about, because we haven't even looked at anything about electrical work yet. So I'm kind of, I mean, I maybe Josh mentioned why all that came up, but like I don't know why that's even being brought up here.
Okay.
Like I don't know how that matters as far as like the fire suppression system is concerned.
When we said, I don't remember the exact things that we said. We said that they had to bring, the electrical system had to be certified. Is that what we said?
So we've been here twice. The first time you guys just said you wanted it to be safe. You want somebody to come back and certify it as safe. That's what we brought a letter from an electrician last time, but we didn't bring the electrician. And then there was a question as to, okay, well, they're safe, but what's the code? And there was a question as to what the code was at the last, and whether what was there was of code. And so we went back and talked to our electrician, who basically said, what code? What are you talking about? Look, this is safe and adequate and fine, and you don't need to reference a code if you don't even need to file for a permit. It's about measuring the service. There's no one answer as to the level, the amount of service for any like number of units or size of a building. It's all about what's there and what they actually are using. So
Sorry, could we roll this back a bit? And forgive me, but I don't recall the prior discussions in detail.
Sure.
What were your refusals for? And can you just retrace how we got to where we are right now?
yes, for sure. I'm going to pull that up so you can see a chart I did with which are basically the things on the refusal. So, we went over these before, but. and,
Yeah, okay, I see these and I see, 2 through 5 are all dimensional issues. Other than, well, 2 through 4, I think all of which we were, I believe, if I recall, comfortable with. The number 5 was something that could be modified in order to either remove the closet or move the door up so the closet is within the unit.
2.26 inches.
The main issue is the requirement for a sprinkler system. What does that have to do with the electrical system? And forgive me for not recalling conversations we had weeks ago.
Yeah, you're very welcome. And there's no problem. So, we're not sure it has any direct relation, but I think, in these cases over the years, when I've had clients who, innocently buy a property like this, didn't realize it wasn't approved, it kind of looks like it is, then, there's a question often, is the electrical separately metered, sub-metered in this case? It's one property, one service. Matt was correct, but then, you could sub-meter it, and we said, well, no. Now, we're going to have a separate commercial and then one for all the residential now, if we're doing these upgrades. But because of that, there was a question, oh, okay, well, it's not. And so you guys had some questions about the electrical, and we went back and got an electrician's report. Now we brought the electrician to just try to make sure that, you guys are comfortable that it's safe, because my client didn't do, basically your questions were because, Ted, was because my client didn't do this work to do the renovations. He bought the property like it is. So it was, all right, well, how can we confirm that it's safe there? And so, that's why we brought Matt Davis here today. He's to run tests, proposed what to do to ensure it's safe.
I think what we did, when we usually ask for meters, whatever type of meters we ask for, because when you buy the place, it was it had 3 apartments in there, and I guess you bought it thinking it was just a 2-apartment building, okay, or a single family home. And what we always say, and what we go by here, is that if it was separately metered each floor or the building, then when you bought it, it was an R2, okay? And even though they didn't tell you that it was an R3. And so we always require, okay, did they have 3 meters, everybody, if there was 3 people in there all the time? That's what we do when we say about the meters. Okay, that gives you a little bit of a variance because you bought it and didn't know that it was supposed to be just only a 2-story build or 2-family building instead of a 3-family building. That's why we ask for the meters. So with and I guess you probably said it, I would think in the last meeting, you would say, we have the electrical code, we have we upgraded the electrical system and things like that, probably the cells, so you don't have to put the sprinklers in. And we would say, okay, well, get it if you get an electrician to say that it meets the code, then we're fine with that. I don't know if that's the exact words, but I think that's how we usually do it. And for Amy and Ted, that's probably what we do when we try to alleviate the sprinkler system, because you bought it not knowing what it was, what occupancy was. So if I'm going back, if that was any of the case, does any of our people in here, does Ted or Amy, do you recall that? Is that how we did it?
We didn't ask about the meters. We just asked about an electrical inspection and the fire alarm certification.
Okay.
Josh, can you bring up the proposed electrical changes again?
Yeah. Matt Davis, you want to briefly describe what you're going to do and your opinion of what the work is going to result in? And if you can see the screen here, you can.
Yeah, so what I found when I went out to the property was I turned on all the electrical appliances and stuff like that and ran some tests. I think we actually have pictures of everything that I did. It seems as though there's a 200 amp panel in the basement that's for the first floor, and then there's a 100 amp meter that is for the second and third floor tenants. And after doing the test, it seems like we're kind of in reverse there, whereas the tenants need the 200 amp as opposed to the first floor. So what we were going to do is we were going to switch those around and remove the existing 200 amp service from the basement and put it to the upstairs and take that 100 amp service and use that for the first floor. And that will give the tenants more than enough amperage for what they're pulling with anything in their units, even all at one time.
And is it, if you were just going in for a permit to do these two, panel changes, would you get a permit, and would that be issued in and of itself, or would that trigger the need for any other
If I specifically put those items on the permit, that's what the inspector would come out to inspect. If he found other things, then I mean, that would be up to him to bring it up to L&I, but typically not the case. Whatever is written on the permit is usually what's inspected.
So you could do this work could be done, and I would agree that, sort of right sizing the, the panels to, what's happening in those apartments. I would agree that makes the building safer. That's sort of a standalone independent thing. I guess maybe, Amy and Wayne, I don't know if we want to caucus for a minute.
Sure.
But maybe that's just the best thing, because I think,
Okay.
I'm not sure
Okay, let's caucus.
All right, yeah.
Let's caucus. Come on. Okay. Richard, is that hair salon or whatever salon you have on the first floor, is that still there?
Justin?
It actually just turned over. It's now an office space.
Okay, so that's an office space, and then there are 3 apartments on the upper floors.
That's correct.
Okay, can you just clarify again what Matt, you were saying? What is the what amperage is going with which units? We're kind of confused at this point.
So instead of splitting up, so with a building like this, the metering came up. With a building like this, with 3 tenants, a house meter, and the commercial space, you would need 5 meters. In order to do that, you would have to pretty much rewire the whole building. So what we're doing is we're leaving the 3 tenants space units in the one panel that is only rated at 100 amps right now, which when I did a testing with all 4 of the electric ranges on, washer, dryer, things like that, we were at around 115 amps, which obviously is not a good thing, even though they'll probably never be using all those things at one time.
Right, so just to clarify, you're proposing to put 200 amps that will take care of all 3 of the apartments?
Tenants, correct.
Okay, and the 100 amp that is currently 200 amps in the basement.
Correct.
Is that also taking care of the first floor? What's the service for the first floor, former salon, current or future office space?
So right now it's a 200 amp. We're going to change that to the 100 amp.
And do you have to do that because otherwise the service coming into the building is not adequate?
No, the service coming into the building is plenty. It's just that it's overkill.
Okay, but
I mean,
to play devil's advocate, could you keep the 200 amp that covers the basement and the first floor and have the new 200 amp for the upstairs apartments?
Yes.
And what's the reason for not doing that, I guess? I hear you saying it's more than you need, but is there a downside to leaving it?
No, but there's some panel work that has to be done on that 200 amp panel for the first floor. Like there's some knockouts that are missing, some wires that need to be reconnected properly. So at that point, instead of taking it out and installing a 200 amp panel, which is more expensive than a 100 amp panel, which will be suffice, that's why I chose to go with the 100 amp.
And would that have been sufficient if there was still a salon there? Because I know we had concerns about that the last time I remember, but or is 100 sufficient only because you have an office tenant in the basement?
It all depends. I mean, the first floor of that property isn't that big, so even a salon that you put in there wouldn't be drawing that much power. I mean, even if you maybe had 4 chairs in there, this is where it kind of comes down to like an engineer would provide your load calculations based on the kind of equipment that would be in there and things like that, as far as it being suffice. But if it was a salon in there again, I mean, it would all be based on how much they're going to try to squeeze in there as far as chairs and equipment that they would be using.
I mean, the reason I'm bringing it up is just our concern is down the road, we just want to make sure that if in the future another tenant comes in there, that you haven't undersized the electric in doing all this.
Well, I think, I mean, and I don't want to speak for Justin. I think that, if a tenant were to move in where they would need more power, I don't think Justin would be opposed to bringing in a separate, a bigger service. It's just not necessary at this moment in time.
Got it. Yeah. Okay.
Because at that time, after this change is made, all we would really have to do is bring in a separate service. We would reconnect the power up to the tenants, and then we would just put a bigger panel and stuff back in for the first floor unit.
Yeah, I think if we're looking at, we're going to be possibly recommending variance with certain provisos, and one of those may be, that it's with the changes you're proposing with the electrical system, with the understanding that the first floor tenant will be for office use, and we may sort of define it that way, just so that again, you can address it down the road if there is a different tenant.
Understood.
Would that be okay with you, Justin, or would you prefer to keep the 200 downstairs? And
That's fine. I mean, I appreciate the point about future-proofing it and keeping the service up, but when it was a salon, frankly, they had, a wax warmer and a couple of lights. They weren't really drawing much power at all. A couple of hair dryers wouldn't broach 100 amps, so I'm fine with Matt's recommendation of bringing it to 100 amps.
you're okay with the limiting it to office use? You're going to use the variance, or would you prefer? It seems like if you want this reduced service downstairs, that's what they'll want. That they'll want it to limit to office use. But maybe you would just keep the 200 panel downstairs, and then it wouldn't need to limit.
Yeah, I think I'd have to talk a little bit further with Matt about the options there. We hadn't talked about that kind of
got to figure it out now if you don't.
Yeah, we're gonna
have time.
We're gonna write it up.
I'm sorry.
Matt,
I just have one thing. I just want to ask the board one thing. Is your concern that if in the future a salon goes back in there, that the 100 amp panel won't be suffice for the salon, or that the whole service won't be enough for the salon plus the tenants?
The first one.
And frankly, this is all because our concern is that because there's no sprinkler system in here, that there's an electrical problem down the road that makes us wish we had a sprinkler system in here.
I guess I'm just wondering what kind of business would draw more than 100 amps? Like maybe a kiln for pottery? I don't know. You know what I mean? I think.
Don't know.
Electrician, I don't know that.
Matt, is there a great increased cost to keeping it at 200 downstairs?
No.
Let's do that then.
So we can do that, and then we don't have to limit it to the office use.
I'd rather overdo it than underdo it for sure.
It's okay with the board.
Wayne, Amy, you good with that?
Yeah.
So basically where we'll end up with is there will be 200 amp service upstairs, 200 amp service downstairs. And then the, either making that closet somehow inside of the unit rather than the hallway. And the dimensional stuff, we're comfortable with those, 2, 3, 4.
Yeah, there's 5 of them, five things.
Right, yeah. Like 3 dimensionals, we're gonna close off the closet and we'll get the fire sprinkler. That's great.
So yeah, we'll make that recommendation to the commissioner, and again, we'll make the final decision, but that's, yeah, I think we're good with all that.
Okay.
And
Good
the
luck, guys.
fire alarm certification should be sent in.
Oh, I think it
It's on
was.
file with the city, yeah.
Yeah, 5.
Okay, all right.
Okay.
Yep.
I'm sorry, this is the court reporter. I missed that exchange. Could you please clarify what you just said?
I asked if the fire alarm certification would be given to the city, and they acknowledged that it has already been submitted.
Thank you.
Okay.
Thank you.
All right. Good luck, guys.
Thanks, everybody.
Thank you.
Okay. Next. We'll be right there. Give me 1 second. Okay, we ready for the next case?
Yes, sir. I believe they're present in the room, sir.
Okay, everybody's in the room, okay. Who's here for 1118, 1120 South Broad Street? Can you tell me your names, please?
Good afternoon. I'm Jennifer Popolak here on behalf of the petitioner. I represent the owner with the law firm of Mattioni Limited.
Okay.
I have 3 witnesses here with me today: Ross Warren, Blake Barabuccio, and Logan Dry.
What's that? Can you give me the second one under Ross? With Ross?
Blake
Blake?
Barabuccio.
Okay.
Barabuscio.
Okay,
I'm
I'm
sorry,
gonna get each one individually, okay?
Okay.
I have to swear you guys in. All right, there's only 4 of you and you're a lawyer. We don't have to swear you in.
Correct.
But Ross, could you please, Ross, state your name?
Ross Warren, W-A-R-N-E.
Ross, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay. Lake, could you please state your full name?
Blake Barabuccio.
Okay, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, and Logan? Where you at, Logan?
Yep, I'm here.
Okay, could you please, could you give us your full name, Logan?
Sure, Logan Dry, D-R-Y.
Okay, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, Phil, could you read that into the record?
Yes, sir. This is
Oh,
MI.
I'm sorry. Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
John Dimes, Fire Code.
Cherry Board Council.
Matthew Wojcik, LNI Supervisor.
Deborah Richardson, Boards Administration.
Philip Motto, Boards Administration.
Okay, Phil, could you read that into the record, please?
Sure. MI 2024-001-910 for the property located at 1118 through 20 South Broad Street. Michael Mattioni Esquire is the Esquire. A representative from his office is present in the room today.
Okay, whoever's going to present the case, go ahead.
Thank you, members of the board. As I stated, I'm here on behalf of the owners of 1118 to 20 South Broad Street. By way of background, on June 22nd, 2023, the owners obtained a use permit for personal vehicle sales and rental with accessory office, car washing, and parking for rental cars in order to have an Avis car rental agency operate in the building. The owners thereafter applied for a building permit, and a notice of permit refusal was issued on March 28th, 2024, due to the lack of a sprinkler system. We filed this appeal on April 1st, 2024, and we have with us here today Blake Barabuccio, who is one of the current owners of the property, Ross Warren, who is a representative of Avis Budget Car Rental LLC, the prospective tenant, and architect Logan Dry. I have some brief testimony for each, if I may share my screen.
Certainly can.
Okay. See if I can figure out how to do that. There we go. Okay. Okay, is everyone seeing my screen now?
We see it, but we don't see nothing.
Just a white page.
Yeah, white page, correct. There we
Seems-
go.
Oh,
There we
there we
go.
are.
Okay. Okay, now briefly, before I bring Blake on to testify, just to give a little bit more background. We have Blake here to talk about the current operations and the operations for decades at the building, which was as an auto body repair shop, Alex's Auto Body, where they engaged in welding, storage of hazardous materials, and other operations, including receiving by tow cars that were recently in accidents. And I understand from Blake, and he'll testify to that further, that the towing of the cars would be at any hours of the day. Avis proposes to operate a car rental business there with no on-site maintenance work on the cars beyond washing and cleaning, and will not be storing hazardous materials, and will have a fleet of cars that are new and will be rotated out approximately every 18 months. And Ross Warren will speak more to that. Avis's operations are much less hazardous and risky than the auto body shop, which has operated successfully without sprinklers for decades. And as mentioned, the use is for storage of vehicles, essentially the same use as the auto body, which stored vehicles on the property. So for this reason, we're requesting a variance from the sprinkler system requirement. Now, if I could, I have briefly, I'll have Blake answer some questions if that's all right. And I understand he's already been sworn in, correct?
Yes.
Yes,
Okay. Blake, can you confirm, are you one of the owners of the property at 1118 to 20 South Broad Street?
I am.
And who are the other owners of the property other than you?
My father,
Okay, and how long has your family owned this property?
1992,
Okay, and what business has been operating at the property?
Alex's Auto Body, since 1992.
Okay. Are there any residential units at the property?
No,
Okay, and what type of structure is the building?
it's like a poured concrete masonry structure.
Okay. And what type of work is being done at the property on a given day?
It's auto body repair, heavy to minor repairs, frame machines, torches, MIG welders, soldering. There's tanks stored on the property, argon tanks and things like that required for welding, soldering, and torches and things like that.
And what days and hours do you guys operate?
Mainly main hours are 5 days a week. There's hours on Saturday. Occasionally people are working on Sunday. As far as tow trucks and activity, 24 hours a day, tow trucks would go in and drop, heavily damaged cars off, any time of the night.
Would the tow truck companies have access to the property to be able to bring the cars in?
Yes.
Okay. Does Alex's Auto Body have a certificate of occupancy to operate a used car sales lot and auto repair, including auto body and fender work and spray painting at the property?
Yes, as you have, there's multiple licenses for all those things you mentioned, and I believe a few more.
Okay, so this right here I have in front is Exhibit 1. Is this a copy of the certificate of use and occupancy for the property?
Yes,
Okay, and then I'll show you our next exhibit, Exhibit 2. This is a permit for hot work. Is it correct that this is a license that was issued to Alex's Auto Body for the performing auto body hot work at the property?
yes,
Okay. And if I move to Exhibit 3, this is a license to store motor fuel and for vehicle repair at the property. Is this a copy of the license for that purpose?
it is.
Okay. Does Alex's Auto Body have a license to permitting them to store hazardous materials at the site?
Yes,
And is this a copy of that license?
that is.
Okay. And that's Exhibit 4. Does Alex's Auto Body have a towing license?
It does.
Okay, and this is Exhibit 5. Is this a copy of the towing license?
Yes,
Okay. Does Alex's Auto Body have an air pollution license?
yes,
And Exhibit 6, is this a copy of the air pollution license for the property?
it is.
Okay, and finally, did employees of Alex's Auto Body have vehicle salesperson licenses?
Several.
Okay, and Exhibit 7 here are these two examples of vehicle salesperson's licenses you have for employees at the property.
Yes,
Okay, and this is Exhibit 7. And did Alex's Auto Body, we just went through a series of licenses for various types of work and permitted uses. Did Alex's Auto Body conduct all of these operations at the site?
yes,
Okay, and I'm going to show you Exhibit 8. This is a series of photographs. Are these photos of the interior of Alex's Auto Body shop?
they are.
Okay, and I'll scroll through them here. Are these representative of a typical operation at the shop on any given day?
Yes,
Okay. Did the building have sprinklers while did the building have sprinklers while Alex's Auto Body was in operation?
no,
Does the building have a fire alarm system?
it does.
Do you have a fire alarm certification?
I do. I was trying to track that down as we were on this meeting, but I do not have it on me, but we do have one.
And with whom is Alex's Auto Body entered into a lease with to operate at the property?
Avis Rental Car.
Okay, and is that lease pending the issuance of a certificate of occupancy?
It is.
And is it your understanding that the Avis's operations, will it include any auto body work, welding, soldering, storage of hazardous materials, similar to the operations that were being done by Alex's Auto Body?
No, seems like the only thing they're going to be doing that Alex's Auto Body did was park cars in the building.
Okay. And then I don't have any further questions for Blake. If the panel be okay with it, I'd like to ask Ross some questions to describe the planned operations for Avis at the building.
Can I just note that a lot of the licenses you just showed were expired, and on Atlas, they're inactive?
Blake, is it correct that Alex's Auto Body is not operating at this time, though? Is that correct?
Everything was put on hold. We weren't expecting this issue, I guess, with the sprinklers. So everything was put on hold and not renewed because of we were expecting to have Avis in there by now.
Okay, thank you for clarifying.
Thank you. Thanks for that question. I'm sorry for not clarifying that previously. Ross, are you?
I'm here.
Okay, so I don't have any exhibits for Ross, so I'm just going to stop sharing my screen temporarily. Ross, could you explain or just advise the board who your current employer is?
Yes, I work for Avis Budget Group and have for approximately 18 years.
Okay, and what's your position at Avis?
I am the director, Northeast Area Development, and that covers Virginia through Maine.
How many locations are operating in that region?
I oversee approximately 320 locations.
Okay. Are you the person responsible for the site at 1118 to 20th South Broad Street?
Yes, I've been working with Blake and his father, for over a year now, trying to get this completed.
Could you describe what the typical operations will be at Avis at this location?
Sure, it's a Avis Budget car rental location, and it'll be operating 7 days a week. We're renting cars to the public. Basically, somebody will come in and to the sales office. We'll go through the contract and get that completed. At that point, the customer would go outside and we would give them the keys to the car to walk around, and they would leave with the vehicle. If they're returning a vehicle, then they would pull into the location, get the keys to one of our employees, and then they would vacate.
What, and you said you would operate 7 days a week. What would be your planned hours of operation?
We're looking to open 7 a.m. to 6 p.m. Monday through Friday, and 7:30 to 2 o'clock Saturday through Sunday.
And what are the plans for how many employees will be on site at any given time?
We anticipate that there will be 3 to 4 employees on site during our operating hours.
And as far as customer access goes, will the customers be permitted in the building anywhere other than the front office?
The customers will not be permitted in the garage or in, they will only be allowed in the retail space in the front office, yes.
I'm sorry, will there be any hazardous materials stored in the building?
No, there'll be no hazardous materials stored in the building.
Can you explain what work, if any, will be done on the cars on site?
Yeah, it's really just prep work. So when a car comes in, we want to clean it. So it'll get washed, exterior and interior. And the only work that would be done per se is if the vehicle was low on windshield wiper fluid. At that point, we would put some wiper fluid in it, and that would be it. Or we wouldn't be doing any maintenance, no work on the vehicles.
Will there be gasoline or motor oil stored on site?
No, there will not.
How old is the fleet of cars that will be on site?
It varies, but typically we get rid of our cars when they become 12 to 18 months old.
How many miles do the cars typically have when they're rotated out? Do you have an estimate of that? Like how used these cars typically get to be?
Yeah, it's typically between 20 and 50,000 miles.
So once the cars are in that range, they're usually about to be getting rotated out and a new fleet brought in with newer cars.
Well, our fleet's always being rotated in, it's fluid, but the cars that we rent out in our fleet, which handles, the north, a car could come from Kansas to, Pennsylvania. So the fleet is very fluid, but all the cars are, sold to at auction at that point, between 12 and 18 months or 20 to 50,000 miles.
Okay. I don't have any other questions for Mr. Warren, unless Mr. Warren, did you have any other comments you wanted to advise the board of with regard to the operations at Avis?
Yeah, I just wanted to clarify, it's not just Avis, it's Avis and Budget car rental. And that's really it. I have nothing else to add.
Okay, thank you. And then finally, I just have some questions for Mr. Dry. Okay. Logan, could you unmute? I think you're muted.
Yep.
There you go. Logan, are you able to see my screen if I share it? So I know you're on, looks like you're on a phone.
Yep, I can see it.
Okay, great. Okay. So Logan, could you advise the board what your profession is?
Registered architect.
Okay. And were you retained to prepare floor plans and a zoning site plan for the proposed Avis car rental facility at the location?
Yes.
Okay. And let me fix my Zoom. Is Exhibit 9 a copy of the zoning site plan that you prepared?
Yes, that looks like the floor plans that we submitted for.
I'm sorry. Yes, it's just the floor plan. Site
Yep.
plans, Exhibit 10. I apologize. Okay, so
Correct.
Exhibit 9 is the floor plan that you prepared for the site.
Yep.
And then exhibit 10 here, is this a copy of the site plan that you prepared for the site?
Yes,
Okay, and in preparing these plans, did you visit the property?
yes.
Okay. Do you have any observations regarding the past use, especially the dangers it posed versus the observations regarding the proposed new use?
Yeah, I mean, and you guys kind of covered it already, but, generally speaking, the building itself was, always designed for vehicles, in terms of its construction, it's the reinforced concrete and masonry. The vehicular use that's currently happening, as everyone alluded to, was obviously much more intensive with, the spray painting, chemicals, welding, noise, body work, that sort of thing. You had a lot of things happening in addition to the cars being, in the building. Whereas, the proposed rental car use, again, far, far, far less intensive use. Even to the extent too that, really the inside is just being used for the prep area of those vehicles, the light cleaning, and then the storage. And even so there, you've got Avis budget employees that are taking care of all the sort of vehicular movements and parking and shuffling and that sort of stuff in the building, from what we observe, again, the actual customer themselves, the furthest they're going to, participate in this property is the leasing office area, and the parking lot out front. As far as anything, in the back of the building where the vehicles and the sort of, back of house operations are happening, like there's no common person even driving a car or anything back there at that point. So, generally speaking, much less intense use than what's currently there.
And based on your experience and in your professional opinion, do you believe there's a justification for requiring sprinklers at the new operation?
No, and again, I know the building code, has certain provisions in it, but I think on a case by case basis, this being a case where you've got, a principal building construction that's not changing and a use that's really not changing except, taking out the hazardous storage and physical, maintenance on the cars. The building itself principally isn't changing. So in my opinion, this would be a case where that the sprinkler system's not warranted. If we were doing something, for instance, that was a residential conversion, or there was, residential as part of it, or even some sort of, additional mixed use commercial, I might have a different opinion, but, because it's still being used for cars and really remaining untouched, I don't think that it's necessary for this particular address.
Okay, thank you. I don't have any other further questions for my witnesses, but if I could just summarize, it's our request that a variance be issued that allow the building permit to issue without the need for a sprinkler system. As stated, for several decades, Alex's Auto Body has been operating the shop, undertaking various extensive and risky work, including welding, soldering, working on cars that are being towed after accidents at all hours of the day, and that are often in poor condition. The new use is a much less risky use, with no hazardous conditions being stored on site, no work or maintenance being done on the properties other than cleaning, and for a much better condition cars overall, because they're going to be steadily rotated out every 18 months, as Mr. Warren testified to. So with that, we're just requesting, as I said again, the variance to permit us to get a building permit without the need for the sprinkler system. And if the panel has any questions, we'd be happy to provide more information. Thank you for your time today.
Well, that was a garage, an automotive garage. Did they use both floors?
Blake, could you answer that?
Yeah, so yeah, we use both floors, yes.
You had cars on both floors?
The second floor was mainly storage, full cars waiting to get fixed. Downstairs is where most of the action takes place.
You have a ramp to get up there to the second floor?
There's an elevator.
An elevator, okay.
I'd also like to add to the speaking about the Avis's cars being new. Obviously, these cars coming in to be repaired at Alex's Auto Body are old, new, 1950s, 2010s, bad shape, good shape, 200,000 miles, 10,000 miles. So there's, obviously much higher risk with that kind of operation versus what they're doing.
And how many cars would be in there at one time?
My estimate, probably 20 or so, 30 upstairs and probably about the same downstairs.
That's when Avis and Budget will be in there, right? They'll have like 40 cars.
Oh, no,
in
that's
there.
just
Oh,
outside.
that's when you were running it. Okay, okay.
Yeah. It would be full to the brim. I mean, you have to walk around cars.
Fire department have any say?
I guess this is a tough one as far as the presentation given. I mean, it is accurate. The building itself, if you look at it, the risk is going to be reduced by the types of materials in there and the type of operation it is. But on another hand, if the building was born today, it would need to be sprinklered. And I don't know if the rationale of saying, well, it used to be a higher hazard building, now it's better, that means it should negate the requirement for a sprinkler when the occupancy type it's going to would have to be sprinklered, or the change of occupancy triggers the sprinkler system. So the argument, or the, I guess, philosophy as well, we're reducing the risk, therefore it doesn't need sprinklers. That's not what codes are. That's not what codes say. Codes say this type of building and this type of occupancy, you need a sprinkler system. So, when it comes to limited occupancy and people just coming in and newer cars, everything they said is correct. But I look at it from a fire department's point of view. I have been in garages with fires, and I have been in, parking garages, which, it's kind of a parking garage where, there's fires and the next car catches on fire and whatnot, things happen. And I understand the risk, and you can, even if it's a small risk, it's a risk. So, obviously it's up to the board, whether or not that, because it's going to a lower level risk factor, would then negate a sprinkler system altogether. I guess that's your call, but it's something I'm suspect on. In other words, if, it wasn't written in error, it's not an extraordinary circumstance. And so what is the reason for the variance? The reason for the variance is that the building used to have a higher hazard, even though this occupancy type does require a sprinkler system. It shouldn't be, because the old use was more risky. Well, that's my perspective.
Aim, Ted, you want to caucus? Okay. Okey dokey. Matthew, do you have anything to say before we caucus?
No, not really. John Dimes kind of summed it up. That fire protection systems in the existing building code aren't judged by the hazard category system that other aspects use. So this is just a straight going from this classification to that classification. Therefore, you need to follow Chapter 9 in the IBC for the new classification. That's what it says. So.
All right, thank you. All right, let's break out. Okay. We heard what you guys said, and in some incidents, you're right, it's a lesser hazard, but we have codes, and we have to go by them. And so we're gonna have to deny this this variance because number one, it isn't that you're tearing a building apart. I mean, you put a wet system in there or whatever type of a sprinkler system you would put in there, but we have to be consistent. And we've had other places similar to this, and we made them put a sprinkler system in according to the code, and we're gonna have to deny your request, unfortunately.
So, I
Um,
mean, my last comment would be is they could remain Alex's Auto Body. They could continue to do what they want, renew a couple of their licenses, make sure they're up to date. And continue to do what they're doing with no sprinkler. They could rent to Mako, auto body, rent to any other body shop, do exactly what they're doing and not require a sprinkler. But car
That's because
rental,
they didn't change the occupancy, that
right, so
they
it's
would.
really a technicality from fixing cars, storing cars, selling cars. There may have even been a car rental license historically, I don't know. But instead of doing that, we're renting cars. That's triggering a fire safety issue.
Not renting the cars, changing the occupancy. You're not.
Right,
you're
because
not-
one operator's renting them, one of them is fixing them, but they're the same, very similar almost identical operation. And if anything, we made the argument that the one is way less invasive, but genuinely,
Yes.
it's an auto operation.
You're right, it's less invasive, but this because, and then everybody would come into this board that say, look, this is a lesser hazard than what was in here, so we shouldn't go by the code.
But it's not just lesser, it's like, so it's not like we're going from, I couldn't even come up with the analysis, but something that's lesser, but completely different. It's almost identical.
But if this use were, was a new use there, or this was being built, it would be required. It's a use that has a risk. We wish that it could be enforced even without the change of use. I mean, it's
Right.
unfortunate.
Well, the triplex is, you build a new triplex nowadays or mixed use building, 100% out of 100 times, you're putting sprinklers in, you're putting 36-inch exits and hallways. So the last thing we heard was smaller doorways, small hallways, no sprinklers. And that passed, but using a 99.9% same operation is not.
Different circumstances.
Basically.
Yeah, we're not, it's
Fire hazard is way worse at the multi-unit property where people live and sleep than a concrete building that has been operating like this since 1992 with no residents.
Blake, what was the use prior to you your family purchasing the property?
Before 1992, it was a Honda motorcycle repair shop and dealership. And then before that, it was some kind of government factory that were building, they were doing something like that, but we're going back some time. So.
But they were selling motorcycles out of there previously.
They were selling motorcycles and we had an auto sales license. So we're talking about auto sales, auto repair, auto rental it's not like we're changing drastic uses here. It's almost an identical use. It's just, and it's the difference between a condo and apartment. It's the same thing. It's just, how it's titled.
Matt, can you pull up what the original building occupancy was when it was built?
You're talking to me, right?
Yeah.
Okay.
You're the only Matt in here, right?
Oh, now I am. Yeah, that's true. Car repairs, I don't really need to bring up before because I mean, like those old COs probably don't even use the same letters for all the occupancies. So car repair I know is S1, and this is going from S1 to S2, which S2 is generally like lower hazard storage, which also includes parking garages. So this is an enclosed parking garage. So enclosed parking garage over 12,000 square feet for the fire area needs sprinklers. That's what this is. S1 and S1 is like the higher hazard storage, which also includes like repair garages.
So we're going down in use. I mean, we didn't.
Yeah, S1, S2. And
Yes,
generally speaking, like it in this case, S1 is like very explicitly labeled in the code as like higher hazard storage, not like group H higher hazard like materials, just higher hazard.
Right.
Yeah,
So
we're not changing the structure around. I would think this would be.
I'm sorry, excuse me, could we please just have one at a time? Thank you.
Sure.
Go ahead, Russ.
I was just thinking that I would assume that this would be grandfathered in. We're not changing the building structure and the use is less intensive.
And it's a similar use. It's an S1 and S2, we're not going from a bakery to a body shop. We're going from a body shop to a car rental. I mean, the triggering is the storage of cars is the storage of cars is already happening there. It's one of the exact uses that we're already doing. We're only looking to take away all the other things. So if, I mean, Avis came in and said they wanted to operate a body shop, it wouldn't change anything. We could have just applied for Avis as a body shop. They don't necessarily have to fix cars to continue the use that we have there.
If Avis was to fix cars in the building, would we then be granted a certificate of occupancy?
Matt?
Oh,
Uh-huh.
I thought that was a question to the board, actually.
No, that's a question to L and I. That's
Oh.
Yeah.
we can determine.
So you're asking like if it was a repair garage?
Yeah, if we
Yes.
were to fix tires and make repairs in the building, would we then be granted a certificate of occupancy? Because we're not changing the
I mean,
use.
it was, I mean, the old CO, which you have, I think the lawyer pulled that up at some point. It may not have like the exact same like letter on it if it's really old, for like that classification, but like if it's the like equivalent of like repair garage, then like they're like, it would technically not be changing if it was like repair garage before, repair garage after, because the IBC would still call that S1 to S1. And at that point, like different rules would be in play for like whether or not we would start looking into like sprinklers being required.
Right, so Ross, you wouldn't have to renew your hot works permit. You wouldn't have to renew all these specific permits. You just have to we have to reapply as you're gonna be doing work and you change some tires and we're all of a sudden, a couple $100,000 saved in sprinkler work. I mean, that's how close this is. That's why, if I sound frustrated, I apologize. But it's
No, but I think
close that we're not changing to something completely different.
Yeah, I think what you're putting out there is you feel that the refusal was issued in error. And I think that we as a board, maybe we need to re-caucus, but if not, Amy and Wayne, whether we simply ask L&I to explore whether that in fact is the case.
Written in error that it didn't go to a higher hazard group.
Sorry, Amy, hard to hear you.
Yeah, it's hard to hear you.
Are you suggesting it was written in error that it didn't go to a higher hazard group, it went to a lesser hazard group?
Well, I'm asking the question. I think that we should ask L&I to explore that. I don't think that if it wasn't written in error, I think we feel that no variance should be granted. But we think it's a reasonable question as to whether it was written in error.
What
Jen,
would
do you
they have to do
follow
to?
that? Sorry.
What would they have to do to follow that? They have to appeal that to L&I or just ask them to look at it? Is that what they would do?
As far as like just whether or not it was written in error.
That
Like,
was
is that-
written in error.
I mean, what was written, I mean, we can only go by what's like on the application, and what was written by the applicant was who was Logan Dry. Proposed level 1 alterations related to rental car sales with accessory office and car wash space, size, location, extent as per attached plans. No auto repair / painting, no structural alterations proposed. So if everything we're seeing says like no auto repair, then like we can't like assume it's going to happen. But like if you tell us afterward, like if now you're saying like, well, if now you say like, well, I guess we could do some repair work, well, then we'll just have to change what we're writing here. Because right now everything is set to say like no auto repair on like everything. So if you're going to be doing auto repair, you got to tell us, because the use permit would allow it. it's broad. It's because the use category in the zoning code covers like rental, sales, and repairs in one use category. So we can't really use that to determine whether or not it's S1 or S2. We can only go by what's on the plans and what the applicant wrote down.
Okay, so I guess regardless of why was no auto repair was specified, maybe that was specified in somewhat of an error to make things seem better and, you know, make you guys feel better about this variance. But I guess if worst case, the application was modified, edited, resubmitted, or whatever, I don't know exactly how it works, but and changed to auto repair included, then we would stay S1 and we wouldn't have this problem.
As far as I know, yeah, because it was definitely, because like I think it's been proven very well that it was definitely auto repair before.
So would that require us to get a new use permit then? Or to revise? The one we have right now does say no auto repair.
Oh, it does. Oh,
Well, if
Let
you
me-
look at, so
check
the
that.
zoning permit issued on June 22nd, 2023 says approved development, personal vehicle sales and rental with accessory office, car
oh,
washing and parking for rental cars only, no auto repair, comma, paint.
oh, it went to the board, didn't it? And one of the provisos was no auto repair.
I don't know if it was a proviso.
No.
Oh, wait, it says all vehicles to be parked within property lines and commercial trash pickup. That's pretty common for all of them. First of all, vehicle sales and rentals with accessory office, car washing and parking for all cars only, no
I'm
auto
sorry,
repair, painting.
Mr. Wojcik,
Sorry.
excuse me, this is the reporter. Could you slow down, please? Thank you.
Sorry, I was just kind of breezing through it. I forgot that you're taking everything down. Yeah, the use permit says personal vehicle sales and rental with accessory office, no auto repair or painting. And that was for a personal. Okay, and that's what. And I was seeing what the applicant wrote down. Change of use to personal vehicle sales and rentals with accessory office, car washing, and rental car preparation with parking as shown on the attached plan. I'm just trying to see where the no auto repairs came from for the zoning permit, because it doesn't say that on the work description.
Yeah, I just want to clarify that the question I was asking was whether it was written in error, even with the being stipulated that there was no auto repair. I wasn't really tying it to, you know, the change of use as opposed to whether the fact that it's a similar but less hazardous use, whether that should be considered as not requiring a variance or as permitted as of right.
Right.
And I'm not necessarily asking you to answer that, Matt, right now. I'm just suggesting that maybe that's something the department needs to take a look at.
Okay.
And the reason I'm saying that is because I don't know that we want to, at the end of the day, be asking for a use permit to be granted that allows auto repair. I think that the fact that a less hazardous use is being proposed is a good thing. And I would not want that to go away just in the attempt to have the sprinkler requirement.
Okay.
That I appreciate that. And just to give you guys a little bit of a backstory, this is essentially my 82-year-old father's retirement. You know, he was going to get out of the business, not continue to run Alex's Auto Body, rent it to Avis, you know, live the rest of his life. Being, you know, I know financial burden is not a zoning variance factor, but, you know, when it comes to the personal decision of my father and myself needing to put out $200,000 for a sprinkler system, it's probably easier to either continue to run Alex's Auto Body, rent it to a Mako, versus an Avis, or, obviously it sounds like there might be a way to either classify this continue to classify it as S1, or what we originally came in to do is, I'm learning with codes now, reduce it down from an S1 to S2 and better the property and safety of the neighborhood versus what's happening right now.
Respectfully, would the board reconsider taking a quorum and rediscussing?
I think we're putting it in L&I's hands, not in our hands. So I think we would have to continue the case.
Right. And we would ask, we meet every 2 weeks. We would like to have, L&I kind of advise us 2 weeks from now. You don't need to attend necessarily. We can do it administratively, but again, we can leave that open. I mean, Wayne, Amy, does that sound?
Yes.
Right?
Yeah, that's fine. That's fine. So what will they do? Submit? Or just, Matt will, discuss that to see what can be done.
Yeah.
And then in the next meeting in 2 weeks, we should have an answer back. And these guys don't have to come in if it's changed, they still don't have to come in.
Right.
Okay, all right, let's have the L&I reconsider
Okay.
it. Okay, all right,
So Debbie, will you put that on our agenda for the next meeting?
for the next meeting.
Yes. Administrative.
Yes.
Okay. The next hearing, I think, is May 2nd.
Okay, next second, Thursday,
Okay.
all right,
For executive, administrative hearing.
okay,
Okay, we could do that.
all right, guys,
Thank you, I appreciate it.
Thank you.
okay. Okay. All right.
There is a single matter remaining on today's calendar, sir?
Yep, we have 225 North 10th Street.
Yes, sir.
Is everybody here?
I believe so. Yes, sir.
One person or
Looks like
two?
two.
Two? Okay, could you tell me your names?
Yes, my name is Han Tong. H-O-N is my first name. T-O-N-G is my last name.
Okay, and your name?
Yes, my name is John Zhao. Spelling the last name is Z-H-A-O.
Okay, what I have to do is I have to swear you in, right? Could you please raise your right hand? Swear to tell the truth, nothing but the truth?
Yes, I will.
John, could you please raise your right hand? Swear to tell the truth, nothing but the truth?
Yes, I will.
Okay, I'm Wayne Miller, board member.
Amy Rivera, board member.
Karagus.
John Dimes, Fire Code.
Ryan McSherry, Board Counsel.
I'm Matthew Wojcik, L&I Supervisor.
Deborah Richardson, Boards Administration.
Philip Motto, Boards Administration.
Bill, could you read that into the record?
Yes, sir. This is MI 2024-002-215 for the property located at 225 North 10th Street. The appellant is John Zhao, Z-H-A-O. He's present in the room today, sir.
Okay, whoever's going to present the case, go ahead.
Thank you, members of the board. John Zhao and I are with the Chinese Christian Church and Center in Chinatown. And the church it owns the property of discussion today, 225 North 10th Street. And John and I are volunteers serving on the church council without salary. The church council is like the board of directors for a commercial company. And John is currently serving as the council chairman and I as the church treasurer. John originally was prepared to do the presentation today, but he is away on company business and is joining this meeting in a car in a remote location. And so he asked me to do the presentation. So today, we are asking for the board's discretion to exempt us from installing a fire sprinkler system in a building that we required about 3 years ago. Okay, so by the grace of God, our church attendees has continued to grow rapidly even after the pandemics. Therefore, we had purchased the adjacent building when it became available in order to increase our ministry and services to the community. This new expansion building will only have restrooms and rooms for Bible studies, fellowships, counseling, and offices. There will be no kitchen, no food heat up, or any appliances that has a risk for fire. The stairways are fire rated and there are multiple fire escape routes, as I will show the board in the drawings in a few moments. And we will have a fire monitoring system. Our church serves many lower income families in the community. Inflation has taken a big hit on our expansion budget, and many of our church members have donated and lent money in order for us to purchase this adjacent building. And we have been raising money for the last 2 years in order to renovate this building for usage. A sprinkler system will cost $200,000, which we do not have the fundings for. And so include the sprinkler system means we need to raise even more money or delay repayment of loans or that we have borrowed from members, and which could also in turn delay the usage of the building to serve the church and the community. So I will, with the board's permission, I will share the drawings.
And thank you. While Han is doing the sharing, I also want to add that the electrical system, plumbing, everything is new in the system, in the building. So everything is up to code. The previous usage of the building was commercial on the first floor and the basement, and upstairs was apartments, multiple apartments. So when we acquired the the building, being that the first floor and the basement was commercial, we did not anticipate that we need a sprinkler system. And we also did not know the sprinkler system costs so much money. Yeah, so that's why we wanted to see if the review board is able to, evaluate whether our building would be able to be exempt from the sprinkler system.
I'm having a little bit of trouble sharing my computer. I guess you are not seeing my laptop, right?
No, we're not.
No.
So while Han is doing that, I just want to describe. So the building is a basement and it's a 4-story building. So each building we would have approximately 2 rooms where we will be using it for either meetings, Bible studies, counselings, and then we also have a few offices in there. But it's all composed of only restrooms and meeting spaces. So that kind of, the risk of having a fire is very low, and our main building right now, we've been in excess. The main building has been built in 1946. We never had a fire before, and we've been very cautious. But at the same time, a building, even though it's a commercial building, is all used by internal church members without any appliance or anything that would trigger a fire risk. So that's where I'm, that's the reason for the appeal. Yeah.
So is the upper floors are being used now for church purposes, or are they still apartments?
So right now, so what happens after we bought the building has been vacant for the last 3 years. The reason for that is because the deconsolidation, it took a very long time because of COVID. We went into issue with the site survey, make a mistake of like an inch or so, and then that dragged on for months. And then when we tried to do this title consolidation, there was an old search that our church still owe money to the church members, which is all clarified. So that took almost another year to clarify. So therefore the building has been vacant. There was like no usage at all for the last 3 years. And so now that, after like a beginning, like early last year, we finally got the permit to start the demolition and the renovation. So right now the building is pretty much all empty. All the framings are done. So now we have to, and then we got this sticker shot of like, oh, you need a sprinkler system. And then when we wait to calculate, we could not afford a sprinkler system. And we actually did not anticipate, because it was only a commercial building. right, on the first floor and the basement. And then of course, upstairs was like, I think it was like 4 apartments total upstairs previously, but we are all turning into just rooms, so we can use it for for the for Bible studies. Because right now we are very congested in the main building, so yeah. Mhm.
I'm sorry, I'm having trouble. I'm sorry.
Sorry if you said this, but I see the basement is sprinklered in the one building. Or did you say the basement and the first floor were sprinklered?
No, so the main building, like the old building that we are not doing renovation, that one is has a sprinkler system in the basement. So at that time when it was built back in 1946, and I'm not sure at what point the city, well, I don't know if it was original or was it added on later, but it was only the sprinkler system is only exists in the basement for some reason. So we have the sanctuary, we have the classrooms on the first floor and the second floor, and at the library, none of that was sprinklered. And I did ask like our old time church members, they said that was the only requirement when they did that at the time. And I've been in this church for 30 years. That's how it has been like that for the last 30 years.
And I was looking at the refusal to try to understand how big each of the 2 buildings are. I don't see it there.
Okay.
Do you know roughly what the size
Yes.
is? Or Matt,
Yes,
whether
I
you-
do. Yes,
Yeah.
the current building or the old building is about 15,000 square feet. And the new building is about, usable wise, is about 7,000 square feet.
Okay. And just to be clear, when you said the new building, that's the 2-story.
Yeah, the new building is a 4-story building,
Is
4-story plus the basement.
Ted, it's an existing building that they bought.
No, I understand, but I'm just,
Yes.
right,
It's
is
4 stories.
the larger building is because I'm
The
not looking
building,
at plans.
yeah, we are not doing anything with the larger building, correct?
Mr. Tom, have you shared screen before? Do you know how to do it?
I had done it before, but I'm having some trouble for some reason. I don't know why.
Can you find the share screen button at the bottom of the
yes.
screen?
Yes, I did. I clicked that button, and then it says
It should give you options of what pictures you want to show.
well, it gives me an option, and I select desktop 1, and then I hit share, and then it says I have to open system. It says open system preferences,
Oh.
security and privacy to grant access. And then when I open that, it's not clear what I have to change.
Deb, do you have anything, any of the pictures?
I don't think we had a packet mailed to us for this one.
Oh, okay, okay.
No, didn't see it.
Yeah, let me see if I can try to share that or using my iPhone. I don't know if that's a possibility. Let me open that right now and see if I can give that a try.
Or if you
Maybe
can quickly email it to Deborah Richardson,
Yes, we can do that. Yes.
Yes.
Let
you
me
can
do
get
it.
it to us and we can share it.
Do you want me to share my screen if we're just talking about looking at the plans?
Yeah,
Is that all you were going to share, Mr. Tom, is the plan?
Yes.
Yes.
The
Okay,
plan, yes.
so go ahead, Matthew.
But
Okay.
Thank you.
Sorry, in the meantime, because John Dimes, I know it's 4:30, and I know, John, you said you had to leave. I just, if you wanted to chime in before you.
I'm just staying here. I'm just parked on the side because
That's okay. I guess how I understand this building, they've acquired a building, they're doing a level 3 renovation that requires a sprinkler system. And their main reason not to do it is more of a financial hardship. Is that accurate?
I think it's both. Yes, one is financial hardship. One is that since the building is not doesn't have anything that is fire risk, right? There's no kitchen, there's no heating facilities, there's no appliances. So it's all meeting rooms and
Yeah.
restrooms. So
Yeah, I totally
Uh,
understand that. It's just, and again, there's a lot of things in the code, even me as a fire code official read and you go, huh, seems a little overburdensome, but one of the reasons for not, I mean, for granting variances isn't because of a disagreement of, you know, personal philosophy of what the code reads. To me, unless there's something I'm missing, it seems kind of straightforward. There's a level 3 renovation doing a change of use to an occupancy type that needs a sprinkler system, and that's what's required. So, I mean, you know, that, you know, obviously all these variances are up to the board, but unless I'm missing something, what would be the reason to grant the variance?
And Matt, is the requirement for both buildings to be fully sprinklered, is that come out of them being consolidated? And, or are there different requirements driving each of them?
Okay, so they're both going to be classified as A3. And requirement for A3 is, well, it's one of 3 different requirements. The first one is fire area exceeds 12,000 square feet. Fire area has an occupant load of 300 or more, or the fire area is located on a floor other than a level of exit discharge serving such occupancies. In this case, that would just mean the first floor. So if you have like assembly spaces on floors other than the first floor, that would trigger that third one. Occupant load, there's no LO signs associated with this. Let me see what your total occupant loads are gonna be. Let's see. Totals, okay, so first floor over 300, okay. Assembly without fixed seats concentrated. 300 or more, and then the fire areas, you definitely exceed those. Because I think the one building is like 15,000 square feet.
Yeah,
This
that's
bigger one
about-
here, and then the smaller one, I think the total came out to 10,000. Where is that math? Okay, but I think this math is for the whole thing in aggregate, which it's being treated as one building, right?
Yeah, the one building is 1 through 4, 929, 933 Spring Street. That's 10,917 square feet. The other building at 2125, 221 to 225 North 10th Street, that is first and second floor, and that's 15,185 square foot.
Is there a firewall between them?
I'll go down a little bit.
And
think these are-
Matthew, I don't want to put you on the spot, but if they could create separate fire areas in the bigger building, would that benefit them?
It could. Let's see here. So the way it's phrased is specifically is an automatic sprinkler system shall be provided throughout stories containing group A3 occupancies and throughout all stories from the group A3 occupancy to and including the levels of exit discharge serving that occupancy where one of the following conditions exists, and I listed them previously. So the way this would work here is that if you can isolate the group A3 fire area with sufficiently rated fire barriers, then you can create isolated like fire areas of A3 that are like less than 12,000 square feet. But you do have that one room that's going to have like 300 people in it, or like a little more than that. So that one, so like potentially that specific room could get. This is so like theoretically you could limit this to like just like the first floor, because it says like shall be provided throughout stories containing group A3 occupancies. So So you can isolate it to just like a first floor fire area. And like sufficiently rate the whatchamacallit, the floor ceiling assemblies.
So if they have their architect go through this, there's a chance that they can create areas and relieve themselves of the sprinkler system?
Well, they won't be able to relieve themselves of it completely without like making it something it's not.
Okay,
So like they could isolate, they just have to get, I guess, perhaps more specific about what exactly these other floors are being used as.
Right.
Because that seems to be the thing that maybe I don't think is quite as clear. Let me get to the, I'm looking at the plan submitted for the amendment. I have to get to the,
And that may be driving the need for standpipes. In the stairs, which
were standpipes required originally? Yeah, they were. I mean, I think the requirement for the, I know for height specifically, I think for existing building code, for standpipes, it doesn't start till like 5 stories above grade or some specific height measurement.
Yeah, there was some
It's,
reference.
it's different than the one for new buildings. Thank you, Andrew. It's 50 feet.
so, all right, that's the basement plan. Can you show us the upper floor plans?
Yeah. And the basement's already sprinkler, which I think was covered earlier.
And what building is that? What? what we're
Okay,
looking at?
so the whole plan is showing the whole, like both buildings in aggregate. You
Oh,
can kind of
okay.
see where they meet with these walls right here, which was like 2 big mason walls that's kind of like stuck up against each other. And there's like openings in the, and there's openings in these walls here, which like, these are technically not party walls anymore because there's no property line here that got,
Right.
that was removed. So there's no issue there as far
But
as
there
we're concerned.
Could be, even though they're opening it up, there could be fire shutters or other ways of isolating the Spring Street building. from
Yeah.
the Street building.
Right. So it could, so this is something where like, I guess the architect would have to go back and be a little more specific about like how they're classifying these walls and like how they're like creating like different fire areas. Because right now it looks like it's just the entire thing is just being treated as one giant group A3 fire area when maybe it's not really being used like that. And like it may not necessarily, or like I don't think they can get out of sprinklers entirely because, well, the basement already has them. And then the first floor has the one room that's going to have more than 300 people. So can't get out of it for the first floor. But like, how are you using the second and third floors? Because right now the whole thing is classified as A3 assembly. Do you have assembly spaces on the second and third floors or higher?
Yes, I just want to clarify. When you say second and third floor, you mean second and third floor of the new building that we purchased, right? Is that correct?
Really,
Just-
can we go to a second floor plan?
Oh, here it is.
Yeah, the large, for instance, the assembly, it's really large, it's classrooms, some large, some small. I mean, Matt, are those considered assembly or only if they're over 2,000 square feet?
Let me just remind myself of what exactly the threshold for the like small assembly spaces rule is.
The largest one here is 683 square feet, the one in the lower right-hand corner I see.
Oh, because it actually has the measurement.
Oh, so the sanctuary, the lodge sanctuary on the left-hand bottom, that does not have a second floor. It's just only one story.
Oh, which one is just one story?
The sanctuary, the left-hand bottom, you see that lodge space there?
Yeah. There's a
Yeah.
part, there's a double height space, but there is a
Yes.
small amount of second floor space in that building as well.
Okay.
But it's all,
Let me go to the third floor.
Yes, and there's no third floor on the
Oh.
old building. Yes.
right. Yeah, the third floor is
Basement
only on the more compact Spring Street building.
Okay, I see what you mean here. So third floor only the one on the Spring Street.
Yep.
Has a third and fourth floor. Okay, so yeah, so this is kind of what I'm talking about. See here, they're all labeled like offices, offices, offices. office, 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 which like, that's group B.
But on the third floor, they were, or the second floor, they were labeled classrooms.
Yeah, which, I guess you could call it group B, but let me just see here. Is this like so when it says like classrooms, is that like like a
yeah, so
school
what we,
operating there?
no, not a school. So it's like
Okay.
what we call a Sunday school. So on Sunday,
Right,
right? On Sunday, we use it for a few hours to do Bible studies.
right, yeah.
Yeah. So we use it on Sunday. Occasionally on a weekday, if we have a Bible study group, like for example, a fellowship, we will probably utilize some of the room as a Bible study. So it's probably use a few hours of like 2 days a week. Yeah, approximately. So that's what the
Okay.
occupancy of the building is. Yeah.
Right.
Because it's mainly on Sunday that we are so congested because we have so many people to come to do worship and then to do Bible study or Sunday school at, in the afternoon. Yeah.
Okay. Now I get it a little more. Okay. So for educational group E, so in this case, the building code has this very specific kind of like provision for like religious educational rooms and religious auditoriums, which are accessory to places of religious worship, which this is. It says that when you have these smaller like assembly rooms, they're and have occupants of less than 100 per room or space, they shall be classified as group A3 as opposed to group E, which is specifically for like kind of like schools, like public schools and stuff. So in this case, this is not like a school that's being run here. It's just like other like assembly rooms for like ancillary like events and like programs and stuff. So in that case, second floor would also, well, the second floor of specifically this building, and these look like, so these are all called classrooms also. So these would also be A3, since these are essentially also like meeting rooms, basically, right?
Yes, that's correct. Yes.
Okay. Okay, so it looks like first and second floor for both buildings, though I think you said the existing building here, this is more like a double height first floor, essentially.
Yes, that's correct.
Okay. So I think first, second floor of both buildings would be A3, but it looks like third floor, the third and fourth floors of the Spring Street building would be Group B, since like they're very like explicitly labeled as offices. So I'm just going back to the top with the code review. Okay. I'm just trying to see how we got those numbers for the occupant loads for the full building. Okay, so 8983. 7126. Okay, so first, second floor taken together. Is the base being used as anything besides like storage?
For the new building that we purchased.
Yeah.
Yeah. So the new building that we purchased is going to be, well, I mean, it's pretty big. So we have the, the gas, not the gas meter. Yeah, the water meter, the electrical panel, those are all in there. So part of it is going to be used for meeting spaces also for Bible study groups. So if we have a bigger group, we probably would be using basement because it's more open. We also, planning for, could it be used as a, a library or a storage? So it's, I mean, I just have to be, to be transparent, because right now that's what our church needs are, because we just run out of space for, for us to do Bible studies. And then, and that's pretty much that we try to, increase the footprint. So then that way, when we actually are doing Bible study, we don't have to cram into a room. Right now we have like a lot of people cram into the second floor classroom. That's what we call right now. So it's getting a little tight, and it's very, very uncomfortable. And that's the reason we bought this. So then that way we can have better space to, to study the Bible, basically. I mean, that's pretty much, yeah. So if it means like for us to, let's say, for example, the basement, you say, okay, if we can bypass the basement and use it for storage, then we move our other storage into the basement, and then we utilize the other rooms, existing room that we have. So we have flexibility to rearrange the rooms, because right now we are just low in space, but we are not, tie into like, yes, this exactly have to serve that purpose. Is what I mean? Because eventually it's the whole church, the old building and the new building is all going to be part of the church. So we can rearrange however usage to make it safer for us, if that makes sense. Yeah.
Right.
I think we're more comfortable with you and your architect kind of sort of revisiting it and looking at, what would be needed to, meet the intent of the code before we consider, a variance. Because I think there are steps that you might be able to do to at least reduce the amount of sprinkler work that would be required.
Is there like any yeah, I mean, when of course we can certainly have the architect revisit, but are there any guidelines or things that we can, because I mean, we don't want to lie saying that, okay, we are not going to use this for this, and then we end up using it for this, right? So, but at the same time, yeah, so we want to be truthful. At the same time, we also wanted to see if there's someone at the board or someone that we can work with to make sure that when we design this, that we design it correctly and truthfully, to meet the requirements.
Right.
That's why the design professional usually handles that and should be able to navigate that for you.
Yeah.
Yeah,
and,
because there's so many ways you could revise that. It's opening up a can of worms if you wanted me to start going through all the possible ways.
I mean,
to
Matt,
yeah.
While they've obviously gotten to this point, is it the kind of thing that they could submit, whether it's through jot form or a preliminary plan review with, kind of submitting options to have a sit down, discussion with the plans examiner? Is there a mechanism, I guess?
You could request a meeting with the examiner of the current application, since at least it would then be the same person. Because with a prelim, you could write down, send it to this person, but that's not a guarantee. But yeah, it would be a meeting with the examiner, where the architect would have to bring their ideas about how to. I mean, at this point, we're really talking about reducing the areas where they would have to sprinkler, not necessarily whether or not they can get out of it entirely, but just putting a fire barriers in certain ways. Because if they have that, they have that one room on the first floor that's going to have an occupant load with more than 300 people, the first floor, at least by code, would have to be sprinklered, and the basement and the basement already is. So there's nothing really you have to do to the basement. If it's already sprinklered in the basement, you can keep the assembly spaces there, as far as I'm concerned. If the sprinklers in the basement work, that is.
And it's also a question of whether to get the first floor, whether that could be done off the existing service, or that would require a new service coming in to do that.
Yeah.
I mean, Wayne, would you imagine it's highly unlikely that the existing service that's just handling the basement
would be able to do the whole, I would be suspected to, yeah. I don't think they would bring, I don't know when it was sprinkled on, because back in the old days when they sprinkled thing, they came in with big stuff, like 6-inch pipe for anything.
Yeah.
I don't know, to see what the feed is coming in. How big is the basement of the first building?
Yeah, so based on the first view, you check in terms of square footage,
Yeah,
I think it's about 1,000, my guesstimate. I think it's about
Oh,
1,000 square feet. Yeah.
I had the number
is the
here.
sprinkler system in
you-
operation in that building?
Yes, because we have to do the sprinkler inspection every
Inspection,
year.
yeah. Do you know how big the feed is coming in?
If I recall correctly, I think it's about 3 inches.
Yeah, probably 4 inch then. It's probably
Maybe
4 inch.
4, yeah.
Yeah,
3 to
don't
4.
use 3, yeah.
And the
Probably 4
basement,
inch.
the basement, it says here is 5,746 square feet.
Yeah.
What? Oh, it's that big? Seriously?
Yeah.
That
Yeah.
doesn't.
And that's including both buildings. And there's some.
Oh,
small
include both
amount of-
buildings. Okay. All right, got it. I'm sorry.
And the first floor is 89, 9,000 square feet.
Yeah.
So-
I don't know what the feeds are, just exactly what, you would have to, what you would bring in. I don't know if it'd be adequate, what you have on a basement, take care of the first floor. I don't know.
Can I ask the board, like, so right now, like, based on what we're seeing on this plan, is it, like the entire building, like everywhere have to be sprinkler, like based on what we currently have designed, or is it only the basement and the first floor need to be sprinklered?
So what was originally approved, since this is a amendment, so what was originally approved was sprinklers throughout and with standpipes in the exit stairways. That was what was on the original approval. That was on the permit and all that.
Yeah.
So at this point, at least as per code, like there's ways you could reduce the areas that need to be sprinklered by being more specific about the uses in certain areas, and like doing some things with like fire barriers to create separate fire areas. But I don't think, without a variance, of course, I don't think you could get out of not installing any more sprinklers than you already have within the basement, just like as is, without us like telling you to change how the building's being used, which like we can't, we don't want to like make it our idea to say you should actually use this part of the building as something else. Like
Yeah,
you would have to come to that conclusion, make that decision, and then come back to us if you want to like change what, like how things are being used to change the occupancy classification of certain spaces.
Yeah, I don't think we want, as the board, we're not going to kind of solve it with you today. I think it's something your
Yeah.
design team and L&I need to explore together. And whether we should continue the case while that happens, that probably seems the right thing, although
It seems like the right thing to do.
yeah, unless ultimately you might withdraw this and resubmit, sort of a separate submission. Does that sound right, Matt, or do you have?
Well, this is an amendment that's being reviewed. So at this point, I guess they could just like withdraw. We put it back into applicant revisions. Well, we'll back it to review, and then we just request that you submit revised plans, and then we review those. So
Okay, and then, but the thing is, with the help that they might need to look what they have to do to eliminate some of the sprinklered areas, who do they get in touch with there, Matt?
as far as like getting like an assessment of like
Yeah, what they
alternatives
can,
being brought.
what they can do to make it less expensive to.
Yeah, because at that point, I think that's what we're talking about.
Yeah.
I mean, if they don't want to like withdraw this or anything like that, and they kind of want to just put this on like hold, basically, then they could submit a prelim as just like a separate application with just like what the architect is proposing as like a revision. Like they can submit that as a prelim if they want, because like right now they can't like directly submit revised plans because the way it is in Eclipse, it like won't let you, I think, because it's in denial. It's under appeal, and like the only way we could like send it back into review is if you like withdraw this whole thing and then submit revised plans. Because we
Yeah,
can't
like,
be,
Matt, in a prelim, could, you know, like say if I was doing something and I would come in and, you know, maybe with my architect or whatever, and say, what possibly can I do? You know, with the plan
Right.
examiner, which, you know, I don't know if their architect knows that,
Yeah.
but whatever.
Right.
He'd have to get rid of this case, okay, and then start over again?
not entirely start over. So right now, like the permit is technically issued. It's just being amended to remove the sprinkler permit, to remove the
Okay.
sprinkler application.
Uh-huh.
So really they would just be going back into the amendment process and just submit revised plans from their architect with like a proposal of how to reduce the area that has to be sprinklered. And then the same examiner would just review it again, and then they can send back the comments, and if it is by right, then it would just be approved as the amendment. And if it's not, then they'll just end up back here.
Okay.
Can I also ask a few more questions?
Sure.
Yes, so do we know if a fire pump is needed? Is that determined by LNR or is that determined by this group? There's a fire, from what I heard, is the fire pump.
They would have to do a sprinkler contractor would have to do calculations on that. I don't know. I don't know what the water pressure is, where that's at. But possibly in the 4-story building, they're gonna need something. I don't know. I'm not sure. The calculations have to be done to see if the water pressure is adequate to get to the right flow at the top floor.
Okay, and then thank you. And then my second question is like the current building, like the old building, it's not considered grandfather because we are consolidated 2 buildings, right? Is that correct? So we still, because the current building, I mean, adding the sprinkler is going to be very disruptive and also costly to our current ministry.
Right. So the existing building, that's the one that was a church, still is a church, right?
Yes, correct.
The one that has this room in it. Right.
Yeah, and only the basement has the sprinkler system.
Oh, right. So only the basement of this building right here, not this one, has the sprinklers in it. Okay. Okay. And so it is true by like demoing this part of this wall here to create the breach in a wall. That does increase the fire area of this like A3 occupancy into this building, and then depending on what kind of fire ratings you have in the floors, it would also go all the way up to the top of that building. So it sounds like this is the building right here that's being converted from whatever it was before. I think you said the one on Spring Street is the one that went from like business on first floor with apartments above or something like that.
Yeah, that's correct. So on the right hand side, right hand bottom, you
This
see
one?
is the two rectangles on the left hand or right hand bottom. Yeah.
Yep.
That's the new building. Yeah.
Yeah, as in newly being added to your property, that is.
Yes,
Not necessarily new as a newly constructed. Okay.
Yes.
Just want to make
And
sure
this
the board
buil-
was clear on that too.
Yes, correct. And this building was built in 2020. I mean 2000. So it's only like 24
okay.
years old. And yeah.
Okay. I'm just getting back to the proposed work plans. Sorry. This takes forever to load.
Matthew, wouldn't a residential apartment building that was built in 2000 need a sprinkler system?
In 2000, I would think so.
Oh,
Yeah.
I'm sorry. I'm thinking
residential-
2020. Okay.
Yeah, it was 2000, he said.
All right.
Yeah,
2000.
2000. Correct.
So I wouldn't know.
Yeah.
I mean, back to the appellant. I mean, you've been through the building, both of them, and like that 4-story building, it definitely has no sprinklers, right?
No, it doesn't.
Okay.
There's no sprinkler system at all.
Okay. Just wanted to double check that. Okay. I'm just trying to think this through here.
And I also want to ask, so that's not,
Excuse me, pardon me,
Oh,
sir, this is the court reporter.
Sorry.
I'm having no, Mr. Zhao, I'm having trouble hearing you. Could you get a little closer to your microphone, please?
oh, I'm sorry. Okay. Is
That's
this better
much-
now?
Much better,
Okay.
thank you.
Yes, okay, yes. I also want to ask, is there like, I mean, truthfully, we are definitely don't have the money to pay for right now, but that's not a possible appeal based on financial burden, right? Is that correct?
That's
Correct.
not what the board does.
Okay, all right, okay. I just want to ask, so yeah, so we have to figure a way, if we have to, okay, all right.
Yeah.
Mhm.
I mean, I can talk with the examiner about this. Just to run something past them. Because like, about just how it was reviewed in the first place. Just because if you're saying like all of this, the 221 North 10th Street building and all that was like already church before, had been used as that, but you know, the whole time. And it's just this other building here that was not used as that before and now will be. Because knowing if all of this in the church building essentially, so this is the same way it's been used, right? As all these classrooms and
Yes,
stuff.
that's
So,
correct, yes.
so over here, these are all existing. It's
Yes.
this one to the bottom right here that's going from whatever was before to these classrooms, offices, and all that.
Yes, that's correct.
Okay. Okay, then that at least I could try asking the examiner about that, just how they reviewed it and see if because these are two separate buildings before, you could like sufficiently rate this wall with like openings and stuff that are also sufficiently rated to make it a firewall such that it gets considered as two separate buildings.
Yeah, we
being
can do
considered
that,
one big
yeah.
building.
Yes.
Which like it
That-
does require work to like put different doors on this.
Mhm.
There's some steps here that may get in the way. You may need to do some things about like these steps here and these openings because any opening along here would have to be rated
Yes.
quite high to make these things be considered different buildings as far as like we're concerned with like code wise, that is.
Mhm. Okay.
I
Yeah,
think we're
that's a
getting beyond our
possibility.
scope.
Yeah.
Yeah.
So
Yeah.
at this point, go to your architects, have them go through the code a little more about like separating fire areas and like into separate buildings and see what they can come up with at this point.
Okay, so I just want to be clear. So when I meet the architect, right, there's one is to see if there's a way to separate the two buildings in terms of like fire code separation, so that way we don't have to touch the existing building on the left, because that would be very disruptive. And then the
Right.
second piece is, I guess, to see if there's a way to at least maybe reduce the sprinkler requirements, so then that way not the entire building need to be sprinkled, and maybe save a little money so we can kind of keep moving, or is it or do you recommend just, you know, just only focus on the first piece, and the second piece, no matter what you do, your chance of needing the sprinkler system for the entire building is pretty high, because if it's pretty high, then we are probably not even going to, yeah, it's going to be very time consuming, and we got the building for like 3 years and we couldn't move in, and our, we keep on growing, so we are running lower and lower in space to a point that we cannot even accept more people coming into our ministry. So that's why we don't want to delay this any further, and so that's why I know nothing is guaranteed, but if this, based on your experience, if you think that, yeah, there's no way you can get by without getting the entire sprinkler system for the new building, then we're probably just going to find a way to borrow more money and just kind of get moving. But if you're saying that, yeah, maybe only partially there's a chance, then we may wanted to consider that. And I don't know if that's something, yeah.
I think you just have to go to the architect and ask him to see if they can come up with some alternatives. That's it.
And then discuss those alternatives with the plans examiner.
Yeah.
Yeah, we don't want to hazard a guess. There are too many interrelated parts on this.
Yes,
Mhm.
exactly.
I don't think we think it's a waste of time. I think it's worth exploring. Because I think there is, you know, as it was submitted, it's sort of very cut and dry, but there are,
Mhm.
as Matt's saying, that you can, by having the two buildings sort of assessed independently, and there are things you have to do to make that happen, that can change the dynamic significantly. So that's not what we're here to do and figure it out today, but we urge you to explore it.
Spoke to your architect, yes.
Okay. Yeah, because my understanding what the architect relayed to me is that the examiner usually doesn't do the reviews and usually just pass it on to this committee. That's why you have to, in order for us to actually even do a review, we have to get the denial letter so we can have this committee to review with us, and so that's how we get here. Yeah, so
Yeah.
Well, what examiner does do to review, just to be clear, is just that the plans that were submitted initially said sprinkler to install sprinklers throughout, at which point not going to look into it much further.
got it. Okay.
So we're
Is
not
there a
going to
way-
ask you to, we're only going to ask you to meet the minimum. We're not going to stop you from going further.
Okay.
To be clear, what could have happened, I mean, obviously, they did, and they investigated the code requirements. They recognized that fully sprinklering was required, and that's why they included those in the original drawings. But they could have, at that point, they could have submitted without them in a preliminary review, asked for, you know, a discussion with L&I to go over the options, and this is before proceeding. And at that point, they could have explored which of these ways might have avoided the need to fully sprinkler. But you can't put it back in the, we're trying to kind of figure out a way for you to do that after the fact. And as Matt says, I think you're in the amendment process. So I think you have an assigned plans reviewer, and I think you want to maximize your interaction with them. But your design team needs to really be factored into this. They're not sitting here today, so.
All right.
So that's what we gotta do, right? We just gotta get. So we have to deny this, right?
No, actually, are we denying it or continuing it, which is?
Are we continuing? Okay, all right, okay.
I'm asking, I'm sorry, Matt, where did we end up with that?
I mean, it depends on whether or not the appellant's gonna have their architect submit revised plan or like plan to submit revised plans, because if they're going to submit revised plans for the amendment specifically, then what they would have to do, like technically as far as like Eclipse is concerned, to make sure things don't get all screwy, is that they would have to withdraw this appeal, which would then put the application back into being reviewed for the amendment, at which point the examiner could just say, submit revised plans that meet the code.
So it's better for them to withdraw it than for us to deny it.
Yeah, I think it's a little cleaner that way, because like technically we have not really made a decision. Well, the board, you guys have not really made a decision per se. It's after discussions, they're going to withdraw and just submit revised plans.
Yeah, that makes sense to me.
Okay,
Okay,
all right,
thank you so much for your help.
all right, guys, no problem. Good luck with
Thank
that.
you.
Thank you.
Thank you.
Okay.
Appreciate your time. Appreciate that.
All right, no problem. Okay.
All right.